We're recording, right? Okay, thank you. It's 8:13 a.m. on April 4th, 2024. These are the hearings of the Oil Conservation Division. We do not have a court reporter today. I think everyone is well aware that there were circumstances beyond our control. We suggested to the parties that if they felt the need for a court reporter to transcribe verbatim today's docket, that they were more than welcome to hire one. We are recording today's hearings via WebEx. That link will be posted. Freya, how will that link be posted?
We're going to have IT help us, so we're not sure yet.
There's already a place on the OCD website where the OCC hearings are posted. It's a link to YouTube, actually. And so it'll be posted in that same area. And if anybody needs help finding it, they can contact us and I'll send them the link to it, but it's on the OCD website.
Okay, so just to repeat what I think I heard is that there is a place on the Oil Conservation Commission site where you post a YouTube link, and that's where you'll post the Oil Conservation Division hearing from today.
Yes, that's correct.
Okay, very good. And when will that be posted?
I would give it about 3 days.
Okay, thank you. So next week, early next week.
Yes. Yes.
Okay, very good. And then it's my understanding that the contract that I helped draft for the court reporter will include verbatim transcripts of the recorded hearings that a court reporter is not physically present in. And Sheila, is that your understanding?
I'm sorry, will you repeat that?
That one of the clauses in the draft contract that we submitted for bidding, not for bidding, but for signatures, has a provision in there that any hearing that is recorded will be sent to them for later verbatim transcript.
Do you know if that's true? I don't know. I don't remember.
I believe that was added
Okay.
to the contract before it was sent out for signature. So that's what I'm going to represent to the parties, that we will have verbatim transcripts at some point, just not immediately. Okay, let's begin. We are calling Franklin Mountain Energy and Matador Production competing applications for a final status conference in cases 23659, 6061, 23811, and 23812. Let me see, we also have 23813. Entries of appearance, please.
Morning, Mr. Examiner. Michael Felderwart with Santa Fe office.
Morning, Dina.
I hear
And
interference,
good morning,
Mr.
Mr.
Felderwart.
Examiner.
I wonder if everyone could turn off their microphones who's not actually speaking. Mr. Felderwart, you're entering an appearance for who?
MRC Permian, Mr. Examiner.
Thank you.
And good morning, Mr. Examiner. This is Dina Bennett on behalf of Franklin Mountain Energy in these cases. And I apologize. I'm stuck in traffic on La Bajada Hill, so I'm not going to turn my camera on. But I'm on my way and happy to take this status conference from my car.
Fantastic. Thank you. Are there any other parties? Mr. Felderwart, you want to start?
Mr. Examiner, I know you set this for a final status conference, but was able to call, or Ms. Bennett reached out to me this morning because she confirmed with her client as well. The parties are in very productive settlement discussions to resolve these matters. There have been some changes in various ownership statuses over the last few months, and that has resulted in some, like I said, productive settlement discussions. We are not at a position yet to dismiss our cases, but I would urge you to perhaps consider setting these matters for another status conference in May or June.
Okay, and Ms. Bennett?
Mr. Examiner, I agree with Mr. Feldewert. The parties are in discussions, and it makes sense to me and in discussions with Mr. Feldewert to request that the division set these for another status conference rather than have this be a final status conference. And I would note that we have Franklin Mountain Energy and MRC have a status conference set for May 16th for some other cases that are part of these discussions. And so May 16th seems like a good date to set these cases for a status conference as well.
What case numbers are those?
Those are case numbers, let's see, 23853 to 23856, 23857 to 23867, 24256 to 24258. Those are the Franklin Mountain Energy cases. And then the MRC cases that I have on my spreadsheet are 24233, 24244, and 24245 to 24249.
Okay, thank you. So Ms. Bennett, are you then representing that case numbers 23659 through 61 plus 23811 through 13 should be consolidated with the case numbers you just gave me?
Not that they should be consolidated, but that they are part of the same negotiations that are occurring. And so just in terms of suggesting a date to which the cases on today's docket could be continued, it made sense to me, since we're already having a status conference that day between these two parties, to continue today's cases to that status conference date as well, but not to be consolidated.
I see. I'm looking at the May 16 docket, and I don't know whether you have continued your cases to that docket, but I don't see the case numbers you just mentioned on that docket. And I know you're in a car. I know you're in a car,
Yeah.
and I know you're
Yeah.
at a disadvantage. So I'm going to go back to Mr. Feldewert, who's in his office, I presume. Mr. Feldewert, do you have any explanation?
Well, first off, I apologize. As I think I mentioned maybe a couple of hearings ago, I'm actually out of town this week, and you were kind enough not to set a hearing this week because I was going to be on beach on vacation. But so I'm not in my office either. But I do agree that they should not be consolidated necessarily. But if you recall, I had a couple of hearings ago, we talked about the chessboard that was going on, and once everything settled down, they would be able to have some fruitful discussions. That's what's going on. So there's discussions about this particular set of cases before you today. There's discussions about the set of cases that are on a status conference, I believe for May 16th. So that's why we're suggesting that perhaps that these cases be continued to the May 16th for a status conference as well.
Mm-hmm. Okay, thank you.
And we can certainly give you the case numbers of the other matters after this hearing if you need those.
Right, thank you. All right, Ms. Bennett, just looking up the first case number you gave me, which is 23853. I think that's the correct case number, is it not?
Yes, it is.
Okay. I show that case filed in September of last year. So that case is 7 months old. It was, looks like it was heard in October. And then it was continued. The last continuance I show, if I'm reading this correctly, was in January, and it was supposed to be heard in March. So these cases are not on the May 16 docket that I see, and they're old. I understand the parties are in fruitful discussions. That's wonderful. But I set these cases that we have on today's docket for a final status conference because of the age of the cases and the number of continuances we've had. They were also set for a, so I'll leave it at that. So what I'm willing to do is I'm willing to set these cases that we have today. And Ms. Bennett, these other cases, I would suggest that you investigate what happened to them and why they're not on the May 16 docket. We have room on the May 16 docket. That's not a problem. And I didn't check every case. I only checked the first one you gave me. But I will set these for a contested hearing far enough out that it gives the parties enough time to conclude negotiations. So I'm going to ask both parties for a date. We're going to issue a pre-hearing order, but we're not going to continue that pre-hearing order for another status conference. We'll give the parties time to negotiate, then we're going to go to hearing, or the parties can dismiss the cases if they come to an agreement. So, Ms. Bennett, how much time do you need to conclude negotiations so I can set this for a hearing?
Thank you, Mr. Hearing Examiner, and duly noted about the other cases. If possible, I'd like to ask the division permission to confer with Franklin Mountain Energy before I tell you how long we need to have to conclude negotiations. But I imagine, just off the cuff, I imagine it will probably be a couple of months.
Okay.
But I don't have a firm sense of that at this particular moment.
Makes sense. I understand. Mr. Feldewert, what do you think?
I have no problem with letting us get back to confer with our parties, let them know your position, and inform them that we need to pick a date for a contested hearing in sometime in the near future.
Okay, very good. So Ms. Bennett, when I'd like to set a deadline for your email to the hearing division with some proposed dates. When will you, what's a good deadline for you to be able to do that?
Would Monday, is that date?
Sorry, bad connection. Say it again.
Okay. Would Monday close of business be okay
Sure.
with you, or is that, okay, great.
Sure.
That would be ideal.
Okay, great. So then we have the 8th of April by close of business. So Freya, would you enter a calendar reminder for that date so that we don't lose track of these cases?
Yes, I will.
Okay, sounds good. So Ms. Bennett, when you send your email, send it to me and to Freya Chance and Sheila Apodaca, so that all three of us can choose one of the dates that you and Mr. Feldewert agree on, and we'll issue a pre-hearing order. And in that pre-hearing order, it will state that we will not reset or vacate for another status conference, that we're either going to go to a hearing on this or the parties will dismiss after their settlement discussions are concluded. Is that understood?
Yes, thank you very
Great.
much. I appreciate that.
And while we're here having these hearings today, I'm going to check some of these other case numbers you gave me to see what the status is, so that when you come here later today, we'll be able to help determine where these cases have gone. Okay, is there anything left on these cases today?
Nothing
No.
for me. Thank you very much.
Thank you. And Mr. Feldewert?
Sarah, that's all.
Okay, very good. So I'm just going to enter some notes here. I am now calling Spur Energy Partners. It is 23872 and 24093. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hingle Shaner on behalf of Spur Energy Partners.
Thank you.
Morning, Mr. Examiner. This is James Parrott with Beatty and Wozniak, representing Riley Permian Operating.
Thank you. Ms. Hardy, are there any other parties?
There are not.
Okay, very good. How do you want to proceed?
Mr. Examiner, the parties have reached an agreement in these cases and are finalizing the paperwork. It's my understanding of where they are. So I don't think we need a contested hearing date. And that is why we had requested another status conference in 2 weeks with the expectation that we would be able to dismiss the cases by then. At least that's Spur's expectation. But given the conversation in the prior status conference, I don't know if it would be the division's preference to let us get back to you by Monday on dates or dismissal.
Well, this is different than the prior cases in that you're telling me, you're representing that the parties have come to an agreement. You're just reducing the agreement to paper. So
Correct.
with that difference in mind, we will, and your clients are willing to continue and pay for the continuance to the next docket or to the?
Yes, they are,
They
Mr.
are willing.
Examiner.
Okay. And Freya, do we have room on the April 18 docket for a status conference?
We currently have 87 cases.
What about the May 2nd docket?
The May 2nd has 40 cases, so that's
Can-
better.
Ms. Hardy and Mr. Parrott, please continue these cases for a final status conference, but in the idea that you're going to actually be dismissing these cases before May 2nd. But that's where I'd like you to continue them to.
Thank you.
And Mr. Examiner, thank you very much.
Mhm.
We will ask for the May 2nd date. My audio went just a little wonky while you were announcing the case numbers. You did announce both 23872 and 24093, correct?
I did, I did, Mr. Parrott.
Thank you. Thank you very much.
Just taking some notes. And Ms. Hardy, you can't think of any reason why by May 2nd, the agreement would not be reduced to paper.
I'm not aware of any.
Are you involved in that?
No.
Oh.
Well, Spur and Riley negotiate directly with each other.
I see. So
So-
they have their internal lawyers.
Or their land departments, yes. Mhm.
Mr. Examiner, if I might be able to add just
Sure.
a little color to that question. My understanding is that the parties are waiting on some banks to also sign some paperwork. So they unfortunately do not have 100% control over the finalization of the agreement. I don't think there'd be any problem with getting all of the signatures they need to finalize the deal by May 2nd. But since there are third parties involved, it's not 100% within the parties' control.
I see. Thank you for the clarification. Okay, is there anything more on these two cases?
Not from Spur, Mr. Examiner.
Not from Riley Permian. Thank you very
Thank
much.
you both.
Thank you.
Calling case number 23944 through 45, 24074 through 76, and 24101 through 102. This is Pride Energy and Matador Production and yes. Entries of appearance, please.
Good morning, Sharon Shaheen, Montgomery and Andrews on behalf of Pride Energy.
Good morning.
Good morning, Mr. Examiner. Michael Felderword with Santa Fe Office of Holland and Hart for MRC Permian and Matador Production Company.
Good morning.
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG.
Okay, and Ms. Kessler, are you monitoring?
That's correct. Thank
Okay,
you.
very good. Did you file an objection?
There's no objection from EOG. We're monitoring because we have an interest that we'll be marketing in these cases.
Thank you for the clarification. So let's start with you, Ms. Shaheen. This is a status conference. Where are these cases going?
Thank you, Mr. Examiner. I have a brief background on these cases if you'd like.
Yes, please.
Pride's applications in case numbers 23944 and 23945 were filed first on October 17th of last year. Matador filed its Wolf Camp applications on December 4th in case numbers 24074 through 24076, and its Bone Spring applications on December 5th, 2023 in case numbers 24101-24102. Since that time, we have had a status conference each month, January, February, March. And the parties have, I believe, been negotiating, but it has not been fruitful, and Pride is not very hopeful at this point. It would therefore like to set these cases for a contested hearing, ideally on May 16th.
Okay, that was very helpful. Thank you, Ms. Shaheen. Mr. Felderwer?
Well, I mean, my understanding is have been some discussions about an agreement to resolve it. But it sounds like Pride wants to move forward with a contested hearing date. May 16th should work. I need to double check if I can.
Let me give you, let me weigh in here on the date. I'm not comfortable adding a contested hearing to a docket. That's not my preference anymore. That doesn't really work for us. And so let's find a date in May around the 16th that works for the parties. Ms. Shaheen, let's start with you since you threw out May 16th.
I believe my client and his witnesses are available anytime in May, but I would need to double check to make sure the geologist and the engineer are available then.
So May 16 is a Thursday. We could do May 14. We could do May 15. Maybe it's better to start on the 14th in case it runs over to the 15th. Are those close enough to May 16 that you can tell me now that those work?
Again, I would have to double check with the geologist and the engineer. We could tentatively set it for May 14th, although I should check my own calendar for that date.
Okay, would you do that while Mr. Felderwert weighs in on May 14?
Yeah, Mr. Examiner, with the caveat that I would too like to just confirm that
Sure.
it's available for our witnesses.
Okay.
We can make that work.
Okay, very good. So I'm gonna select May 14. I'll give the parties, Ms. Shaheen, how much time do you need to check with your geologist and you look at your calendar and confirm May 14?
If we could have until Monday, that would be great.
Perfect. Monday.
Okay.
Monday, April 8th. Mr. Felderwert, does that work for you?
Yes.
Okay, wonderful. And Ms. Kessler, will you be participating?
I'll be observing.
Good.
That's fine.
But you'll be here?
Correct.
Okay, very good. Just a note to parties, if you're involved in a contested hearing, I expect you to be here in person unless we don't have the room. And if we don't have the room, then we have to do it virtually, but I don't want to do contested hearings over the phone or through video. Your witnesses can appear by video. That's fine. Okay, so what we have determined is that unless we hear I think either way, Ms. Shaheen and Mr. Felderwert and Ms. Kessler, please confer and send an email by close of business April 8, advising the hearing division that May 14 is acceptable, and we'll issue a pre-hearing order on that for that date.
Thank you.
Thank you. Anything further on that case, on those cases?
No, thank you, Mr. Examiner.
Thank you. Okay, I believe the next set of cases on our docket is 24146 Mewbourne Oil, consolidated with 1718. Wait a second. It says here in the notes that Mewbourne Oil case is consolidated with 24146 through 24149. So I apologize, I announced that wrong. So I'm calling cases 24146 through 24149. Entries of appearance, please.
Mr. Examiner, Jim Bruce, representing Mewbourne Oil Company.
Thank you, Mr. Bruce.
Morning, Mr. Examiner. Michael Felderwart with the Santa Fe office of Holland and Hart on behalf of MRC Permian. And we have filed competing cases which are on this docket under case numbers 24324 through 25.
Let me call those cases then, 24324 and 24325. And let me see if those are, they're not, oh, Mr. Felder, what lines are those on the docket?
Yeah, give me a minute. I'm trying to find them as well. Here, I saw
26
them.
and 27.
Thank you. Okay, so they're not, okay, very good, thank you. Mr. Bruce pointed out 26 and 27.
Correct.
All right, so these cases, Mr. Felder, should be consolidated with the cases I called initially for the purposes of a contested hearing, is that right?
Yes, they involve the same acreage.
Okay, let me make a note of that before I lose that. Mr. Bruce, what were the initial cases that I called?
24146 through 24149.
Thank you, sir. This is 24325. Let's go back up here now. I'm just doing a little housekeeping, Mr. Bruce. With competing. Mr. Felder, when did you file the competing cases?
We filed them a month ago because they're for this docket.
Thank you, sir. 2, 4, 2, 4, 2, 5. Got it. Okay, Mr. Bruce, you have competing cases. How do you want to proceed?
At this point, I'm sure the parties will be in touch with each other, but I think they should be set up down the road for a contested hearing.
When were your cases filed? When did you file in your cases?
I believe they were filed in February.
Oh, just they're brand new then.
Yes.
24146. Let me see when it was filed. Unless someone knows better.
Not me.
246. Let's take a look. Okay. So it looks to me, Mr. Bruce, that you filed your case January 2nd. Is that possible?
Yes.
Okay. And then we had a hearing set, then we received, well, Mr. Felderwart, did you enter an appearance and object?
Yes.
Okay, I don't show that in our list of actions in Mr. Bruce's case. So I need to look at the actual imaging. Give me a moment. Let's see what this is. Here's your entry appearance and objection, and this is from January 19. Okay. Okay. All right. Mr. Bruce, I don't think my preference is to set this for a contested hearing yet. This is a relatively new case. Let's have one more status conference. Let's see how the parties are doing. Mr. Feldward, is there any possibility that the parties will resolve the issues and you withdraw your objection, or do you not see that as possible?
No, I think that is a very real possibility. I know the two companies tend to work very close with each other. And so I think there's a decent chance that they can get things resolved.
Okay.
We just needed to get our competing development plan on paper filed so that the parties are in a position to get this thing resolved.
Okay. So Mr. Feldward, if I was going to set another status conference, how far down the road would I do that?
I would say June.
Okay. Freya, which docket in June should I set these for?
June 13th is available. June 27th is also available.
Interesting. Those are the regular dockets in June on those dates?
They are.
Interesting. So we'll do June 13. Let me take some notes here in these cases. Mr. Bruce, are you okay with that?
Yeah, I'd like it a little earlier, but 13th is fine.
Okay. Thank you for being flexible. So Freya, will you show on the June 13 docket that these Mewborn cases are consolidated with the new competing cases from Matador, 24324 and 24325?
Yes, I will.
Thank you. And of course, the parties have to file continuances to that docket. Status conference June 13. Okay. Anything else, Mr. Bruce or Mr. Feldwart?
Thank you.
No, Mr. Examiner, and this is my last case, so I thank you for accommodating my virtual appearance.
Yes,
My virtual appearance and my appearance today. Thank you.
Wonderful. Enjoy your vacation.
Thank you, sir.
Thank you. Okay, we are calling Marathon Oil. Well, actually, no, let me go back because I think we've skipped over some cases to get to that. Let's go to Riley Permian Operating 24279. It looks like also 24280. We're here for a status conference. Entries of appearance, please.
Mr. Examiner, good morning. Ernest Padilla for Riley Permian Operating.
Good morning, Mr. Padilla. I'm going to ask you to repeat that and say it loudly because we're relying on the recording to pick up everything today, and then a court reporter will transcribe this once we have them under contract again.
Okay. Ernest Del Padilla, appearing for Riley Permian Operating.
Okay, thank you, sir. Any other parties?
Mr. Examiner, Dana Hardy with Hinkle Shaner on behalf of VF Petroleum.
On behalf of who?
VF Petroleum?
BF, B as in boy, F as in Frank? BF, thank you.
VF, yes, thank you.
And good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Colgate Production LLC, Permian Resources Operating LLC, MRC Delaware Resources LLC, and MRC Permian Company.
Thank you. Mr. Padilla, from your own knowledge, who filed objections?
Well, Matador, Permian Resources, and VF Petroleum.
So both parties, okay. So both opposing parties.
On both cases.
On both cases, very good. Okay, so Mr. Padilla, and please speak louder or get closer to the microphone because it's very hard to hear you. How do you want to proceed with these cases? First of all, Mr. Padilla, when did you file these cases?
On February 14th.
Excellent. How do you want to proceed?
Well, it appears we have to go to a contested hearing on these. The nature of saltwater disposal is going to be, it appears that we're contested, and the companies that are opposing the applications don't want them there. So I don't see any choice other than going to a contested hearing.
Okay, and when would you be ready for a contested hearing?
In May or April. It doesn't.
Well, we're in April now. Are you saying that?
I'm sorry, May or even into June.
Okay.
Whatever the division's preference is in terms of setting these cases.
Okay, all right. Let's now go to Ms. Hardy.
Mr. Examiner, I agree. It seems these cases need to be set for a contested hearing, and I would just need to confirm availability of my witnesses once we have some dates.
Okay, and Ms. Vance, your microphone's off.
I also agree that a contested hearing is probably appropriate. However, I think a contested case for June or July would probably be better. That way there is some time for the parties to confer and, figure out some of the concerns and objections.
So are you suggesting that waiting until June instead of having it in May would allow the parties to reduce the amount of evidence and reduce the issues at hearing?
I believe so, yes, Mr. Hearing Examiner.
So let me ask both parties, and I'll start with you, Ms. Vance. What are the objections to this saltwater disposal?
At this point, I think that that's what we're trying to look at right now. So it's not quite clear yet. And that's again why I'd ask for some additional time and push out to that June or July hearing date so we can have time to form those.
Are you going to have witnesses?
I'm not sure at this point. So again, it's still early on, and that's why we would ask for that additional time.
Ms. Hardy?
Mr. Examiner, VF has concerns about the impact of injection on its producing wells in this area. It holds the lease. And so we would have a witness. We would at least have one witness who would be a geologist.
Okay. Okay. So Mr. Padilla, you've heard from the opposing parties that they would like to have the contested hearing earliest in June so that the parties can reduce the number of issues that come to a hearing and reduce the amount of evidence that the division has to consider. Are you in agreement with that or not?
Not necessarily, Mr. Examiner. I think July is too far into the future for these cases.
Mm-hmm.
I know Riley has talked with some of the opponents and have tried to figure out, get together with them about the disposal applications. These are not commercial applications. They're lease applications to dispose of produced water on producing acreage. So I wouldn't want it to go into July. I think there's some merit in talking by the parties to try and resolve the issues, but I don't think that going into July is appropriate. I think June would be fine.
Okay. That was the month that I had suggested was June. So I think we're on the same page here. My preference would be to have this contested hearing either on June 4, June 11, June 18, or June 25th. So that gives the parties 4 days to choose from. And Mr. Padilla, I'll ask you first, does the close of business April 8 give you enough time to confer with your client and with the other parties to establish a date?
Yes.
Okay. Ms. Hardy?
Yes, that's fine. Thank
Ms.
you.
Vance?
Yes, that's fine. Can you repeat those dates one
Sure.
more time?
They're the Tuesdays in June, basically.
Okay.
June 4, 11, 18, and 25. If the parties can agree on a Tuesday, we could agree on a Wednesday. Thursdays are not great because of our docket schedule. However, we don't have a docket on the 6th or the 20th, so even those Thursdays work. So there's about 9 or 10 days there that the division could conduct a special hearing. This will not be part of a regular docket.
Mr. Hearing Examiner, are you looking to have this in person or WebEx?
In person.
Okay, June 18th and 20th, this hearing room is not available.
Perfect, thank you. So you can strike those dates from the, what I said before. Thank you, Freya.
What were those 2 dates? I'm sorry.
She mentioned the 18th and 20th are not going to work for the division.
But the 4th, 11th, and 25th are probably.
And the 5th and the 12th and the 19th and the 26th and all the other dates I mentioned are in play, Mr. Padilla.
Thank you.
Okay, thank you. So we will expect, and we will have a calendar reminder to expect an email from the parties with the dates. Let me just take some notes. Okay, is there anything else on these 2 cases before we move on?
Not from Riley.
Okay, Ms. Vance?
No, nothing else.
I'm now going to call COG operating 24284. I don't believe this is consolidated with any other case. Entries of appearance, please.
Mr. Examiner, Dana Hardy on behalf of COG Operating, and you're correct that this case is not consolidated with any others.
Thank you, Ms. Hardy. Are there any other parties?
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG.
Ms. Kessler, did you file an objection?
No, we did not file an objection. I believe another party did.
And is there another party?
Morning, Mr. Examiner. This is James Parrott with Beatty and Wozniak representing XTO Energy.
And did you file the objection?
We did file the objection. Thank you.
Okay, very good. Are you filing a competing case or application with this?
You know, the parties just recently engaged in negotiations regarding a potential trade or participation. And so it's a little too soon for that decision to happen.
Okay, thank you, sir. Ms. Hardy?
Mr. Examiner, COG has been communicating with XTO about these wells since October of 2023. That is when it sent its well proposal. Actually, I believe it was sent in November, and the proposals have been updated, but these wells have been in the works for a very long time. COG and XTO have gone back and forth on trade proposals since last fall. At this point, COG would ask that they be set for a contested hearing in June. And I think that's plenty of time still for the parties to come to a resolution if there's going to be one. So that's what we would request.
Okay. Ms. Kessler?
That's fine with EOG. We need some time to work through a title issue with COG, but that should give us sufficient time to do so.
Do you anticipate having witnesses at the hearing?
We don't anticipate at this point having witnesses.
And before I go to Mr. Parrott, Ms. Hardy, how many witnesses do you anticipate?
2 to 3.
Okay, very good. And Mr. Parrott?
Mr. Examiner, thank you. It's my understanding from discussions with my client that negotiations really only began in earnest very recently, and that there are some very real possibilities for resolution, which would obviate the need for contested hearings. But the package that is being packages, I should say, that are being proposed by COG operating are very large. In one case, we've got 12 wells, multi-mile laterals. So we have hundreds of millions of dollars in capital commitments that COG operating is requesting, and those decisions should not be rushed. XTO would prefer a status conference be set in June for both of these, although I would note that these cases are not appropriate for consolidation. They involve different issues and are not, they don't really have much in the way of commonalities. So requests that we have status conferences in June. I think 2 months would be the minimum amount of time that would be necessary for the parties to have any kind of meaningful negotiations, and forcing the parties to come to some kind of resolution sooner than that is just going to substantially interfere with the negotiations. This would be the metaphorical sword of Damocles hanging over the negotiating table. So the more time the parties can have to negotiate a settlement before they have to come back and inform the commission of whether competing pooling applications are expected, or a contested hearing is going to be necessary, the better chances we have of resolving these without the need for a contested hearing. Thank you.
There were a few things you said that I want to clarify. First of all, you said this case is not appropriate to consolidate with another case, but it's not my understanding that this is consolidated with any case.
Okay, good. I might have misunderstood. I thought that there was a reference to the other COG operating case that was protested by XTO, which is 24286. So my apologies for my confusion. I thought there was a reference by somebody to more than one case. So just to be clear, we're only talking about 24284.
We are.
Okay, thank you. So then we can just stick to that case. Thank you.
Yes, of course. And then you mentioned something else. You said that negotiations had really only just begun recently, yet Ms. Hardy said that the proposals were sent out in October of 23. So that's 6 months ago. Why is there a difference there?
So I believe that she also mentioned that revised proposals were recently sent, and I believe that at the time that proposals were sent, there had not been a prior discussion. So, it's I think somewhat uncommon for XTO when dealing with a proposal for several $100 million worth of wells to be first contacted via an election letter. There would typically be some kind of communication prior to that. So, I don't think that in this case, sending an election letter really constitutes good faith negotiations. And I think that good faith negotiations have really only begun in earnest much more recently.
Yeah, that's helpful. Thank you. Ms. Hardy, back to you. Have there been revised proposals sent?
The proposals were updated with respect to the well costs. AFEs were sent, I believe, in January. But the parties have been exchanging trade offers for 5 months. So I think that setting a contested hearing in June is the way to get these moving. And I think that's more than enough time, considering the amount of time that's passed since the proposals were sent. I don't think that's unreasonable at all.
Mr. Examiner, if I might be able to provide a little bit more color on the history here.
Sure, I'll come back to you, Mr. Parrott, in just a moment.
Thank you.
So, Ms. Kessler, you've heard both parties. If I were going to set a contested hearing, when would it be?
Mr. Examiner, we're not taking a position on the contested hearing date. I will represent to the division that we have been having discussions with COG operating for quite some time on a title issue. That title issue remains unresolved. So the discussions have progressed. That's EOG's perspective on the case. And, I haven't been engaged certainly between the discussions between those two companies.
And in your opinion, I don't know about the title issue that you're talking about, obviously, but in your opinion, is this taking longer than usual to resolve the title issue?
It's a complex issue.
It's a complex issue.
Yes.
When did you start dealing with this issue?
A year and a half ago.
I see.
That's an approximation.
Right.
Approximately a year and a
I
half
see.
ago. And this is not me, this is discussion through Landman.
And Ms. Hardy, are you aware of this title issue?
At a very high level, but I'm not aware of the details, but I understand that COG and EOG are working it out.
Yeah, are they close to resolving it?
Ms. Kessler might be able to give you more information on that. I think prior communications with her, I think we thought that June would be a sufficient amount of time.
That's correct.
So what the parties are telling me is that if we had a contested hearing in June, the title issue would most likely be resolved.
I think in setting a hearing date from EOG's position exclusively will help resolve the duration of negotiation for the title issue, having an end date, but that has no bearing on any other parties.
Ms. Hardy, before I go back to Mr. Parrott for further color, he mentioned that there was an election letter sent in, I guess it was October, I'm not sure when.
November of 2023, that's the well proposal letter that sets out the location of the wells, the development plan, all of that.
And by his representation, he felt as though that wasn't good faith negotiation. What do you have to say about that?
Well, under the division's prior cases, it's well established that sending an election letter 30 days before you file a pooling application is the trigger of good faith negotiations. I mean, that's typically what meets the requirement. So certainly sending a well proposal letter 5 months before you file a pooling application and engaging in trade discussions for 5 months is absolutely good faith negotiation.
And this case is more than just a compulsory pooling, right? It's something else as well?
I believe we're asking for non-standard spacing units, but that's just because of the large size of the units.
There's an abbreviation here that says EDD. What does that mean?
EDD.
It says CP, compulsory pooling, comma, EDD.
On these, EDD.
While you're looking, I'm going to go back to Mr. Parrott. Mr. Parrott, do you know,
What?
okay, you were going to give me some more color on this. Go ahead.
Yes, thank you. So just a quick response to Ms. Hardy's point that the well proposal under division guidance is good faith negotiations. All that does is establish a rebuttable presumption of good faith negotiations.
Okay.
Certainly when a party comes in and starts engaging in negotiations, there would be a much higher standard than where a party just simply does not appear. Regarding the history of this particular area, XTO holds a full section within the proposed unit. It is a state land office section. So XTO has a very substantial interest in this unit. COG proposed to put a surface location on the XTO leasehold. And when that was initially proposed, there was a JOA in place that would have allowed that surface location. That JOA expired. And so that surface location is no longer allowed. That surface location conflicts with XTO's development plans, and there are some pretty intense reclamation and environmental liability concerns where COG would propose to put a 12-well pad on a surface location that is on XTO's state land office leasehold. As you're probably aware, state land office will look to the lease owner for any reclamation or environmental liability, regardless of who the operator is. So these are issues of very significant concern, and the expiration of the JOA caused a shift in the negotiating aspects here. And so regardless of when the election letters were sent, the negotiations that are currently happening had to shift because of that recent expiration of the JOA. So again, here, XTO would have a very substantial contribution because it owns an entire 640 acres within this proposed unit. COG is proposing hundreds of millions of dollars worth of well bores, and it is not just or equitable to ask XTO to make development and capital commitments for $60-100 million within a period of a couple weeks. So at this time, we would ask for this matter to be set for a status conference in the not too distant future. We could look at something maybe a little earlier than June, but certainly it's not appropriate to set this matter for contested hearing at this point. It's going to substantially interfere with the parties' negotiations if that happens.
Okay, thank you, Mr. Parrott. So Ms. Hardy, I've decided to set this for a status conference on May 16. And if the parties have not made substantial progress in their settlement negotiations and their title negotiations, then I'll set it for a contested hearing. So basically, this will be a final status conference on May 16. It's based on the age of this case. This case was only filed in late February. And I do understand the parties' representations of the complexity of the negotiations here. So that's why I'm going to set this for a final status conference on May 16. Okay.
Thank you.
Thank you, Mr. Examiner.
Yes, of course. And Ms. Hardy, may I suggest that if substantial progress isn't made and you know that I'm going to ask you at the May 16 docket for hearing dates. So if you would confer with Ms. Kessler and Mr. Parrott before the hearing, that will help me expedite this set for a for a final contested hearing.
Absolutely, I will do that.
Okay, I'm now going to move on to 24286. Entries of appearance, please.
Dana Hardy on behalf of COG Operating.
This is James Parrott with Beatty and Wozniak, representing XTO.
And did you file an objection?
Yes.
Okay. So Ms. Hardy, where are we going with this case?
Mr. Examiner, this case is similar to the prior one, although in this one, XTO owns a much smaller interest in the spacing unit. They only own a 12.5% interest, and the parties have been negotiating for several months. COG sent its well proposals in early December and has been communicating with XTO. So it's now been over 4 months, and COG would like to have this set for hearing. Again, we would prefer a June hearing date. I think given XTO's very small interest in the spacing unit, it's not reasonable for them to hold up the hearing, and I think setting a hearing date would move the parties forward in their negotiations.
And before I go to Mr. Parrott, it looks like this case was filed a few days later than the other case. It looks like March 1st is when the division received the original filing. And so a month later, here we are for our first status conference. So thank you, Ms. Hardy. Mr. Parrott?
Thank you. So Ms. Hardy's correct. XTO has a smaller interest in this unit, but this is still a multilateral package that's going to be over $100 million. So XTO is being asked for a capital commitment of over $10 million. That's a significant commitment for a non-operated position. There's been somewhat of a history of XTO making these capital commitments for COG projects, and then the wells are not drilled for some period of time. That capital commitment ends up being on XTO's books for a substantial amount of time. So XTO has similar concerns about this matter proceeding to a hearing before the parties can have some meaningful negotiations. And my understanding is that the negotiations for the prior case and the negotiations for this case are somewhat interrelated. When there's trades and deals on a table, sometimes it's helpful to have those pieces interrelate to facilitate the deal or trade getting done more easily. So XTO's position is that it would make sense to have the schedule for 24286 mirror the schedule for 24284, although the hearings themselves would be different. With that being said, if the division feels the need to set this for a contested hearing immediately, which seems premature since this is the first status conference only 2 months after the filing of the application, we would request that contested hearing be set as far out as reasonable. Thank you.
So let me ask you some questions, Mr. Parrott. This case, it sounds like, is simpler than 84. Is that right?
I'm not sure that I would necessarily agree with that characterization. By simpler, I'm not entirely sure if you're referring to the lack of the surface location issue. If that's the case, then you're correct. My understanding is that surface location issue on a state land office lease does not apply in this particular situation. But otherwise, I don't know that there is any material difference in the complexity of the two cases.
So the fact that you own, what is your interest in 84? It's 12% here. What is it in 84?
I believe it's 50%.
Is it? Okay. Ms. Hardy?
I don't have the numbers off the top of my head for the other case. For this case, it is about 12.5%, which is a much smaller number.
And Mr. Parrott, you objected to this for some of the reasons that you mentioned during your discussion with me today.
So the objection, in addition to some technical concerns that we would be discussing at the hearing, the objection to XTO being force pooled right now is that there simply has not been enough time for negotiations to mature. And in XTO's viewpoint, COG has not made a good faith effort to obtain the voluntary pooling of the other parties in the unit. Given the magnitude of the capital commitments, it's just unreasonable to expect a company like XTO to make a commitment within a month or two. Usually negotiations between companies the size of Conoco and XTO are going to take a little bit longer than that. And generally speaking, those companies will provide a little longer runway for their drilling plans to allow for those sorts of negotiations.
Okay.
So, a few more weeks is just not going to be enough time for those negotiations to mature, and having a hearing at which COG would have to meet its burden of demonstrating that it made a good faith effort to obtain XTO's participation in sometime in the next month or so is just not going to be a realistic prospect. Thank you.
And why shouldn't the two cases be consolidated for a hearing?
Well, they are different areas. They are, first of all, there's the state land office lease issue in the 8.4 matter that is not present in the 8.6 matter. That would have a substantial impact on XTO's development plans, and that particular issue would not be present in the 8.6 matter.
Ms. Hardy?
Mr. Examiner, the cases are different. I don't think they should be consolidated. And may I respond briefly to Mr. Parrott's discussion?
Yes.
So the capital investment for XTO in this case in 24286 is going to be much, much smaller because they have a much smaller interest. And this case is simpler. It doesn't involve the state land office lease issue or the surface location issue. COG is confident that it has been negotiating in good faith, so we're prepared to go to hearing in June and address these issues at that point.
Okay. What I'll do is I'll set this case for a status conference on May 16. The parties can then discuss a hearing date in July. We'll set this for a July contested hearing upon the parties' representations of a date that works for their clients, their witnesses, and for themselves. Is there anything else?
Not
No,
from
thank you, Mr.
COG.
Examiner.
Okay,
Thank you.
thank you. Let me take some notes and then we'll move on. I am calling COG operating 24320, consolidated with 24321. Entries of appearance, please.
Dana Hardy on behalf of COG Operating.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Cimarex.
Good morning and welcome.
Thank you.
Do we have any other parties?
I don't believe so.
Okay, very good. Ms. Bennett, did you file an objection?
Yes,
Okay.
I did.
When, do you know when you filed your objection?
I filed the objection, I don't have the exact date,
Sure.
but I would say probably last Wednesday.
Oh, so very recently. Okay.
Yes.
And Ms. Hardy, when did you file this case?
This is the first docket setting for this case.
Excellent. How do you want to proceed, Ms. Hardy?
Mr. Examiner, I think that Cimarex is planning to propose a counter development plan, although they wouldn't need to pool it because they're proposing to develop under a JOA. So I think we need a contested hearing date and would ask for a date in June if possible.
Now, Ms. Hardy, let me clarify. If Cimarex, that's right, isn't it? If Cimarex is going to file a contested or a opposing competing pooling application and they haven't done so yet, how could we go to a hearing that quickly?
I don't believe Cimarex is planning to file a competing application, but perhaps Ms. Bennett can
Okay.
provide a little more
thank you.
information.
Thank you, because I'm a little confused. Ms. Bennett?
Thank you, Mr. Examiner. Yes, in these cases, COG is seeking to pool interests in two sections, section 6 and 7. And Cimarex is the designated operator under a JOA of section 6 and has the right to drill wells in section 6 without going to pooling because it's the designated operator under a JOA. So what that means is that, and I would also note that COG is a party to the JOA. So COG sent out proposals on, I believe it was February 8th or 12th for these wells, then filed its application on March 4th, so did not wait for the full 30 days to file its applications before doing so. And Cimarex responded when it received, or shortly after receiving COG's proposals, reminding COG gently that Cimarex has a JOA over section 6 and that it intends to develop its acreage in section 6 for which it's the designated operator. So at this point, I do agree with Ms. Hardy that absent COG dismissing its applications, we will need to go to a contested hearing. And we would like a contested hearing in June.
Okay.
To answer the division's questions more specifically, though, Cimarex will be proposing wells under the JOA, but that is not something that will trigger a compulsory pooling case because they don't need to pool anyone, but they still have to propose under the JOA, and they're doing that in the near term.
Okay. How long will you and Ms. Hardy need to confer on the dates? And I gave some dates earlier to other parties. I don't know if you were here for that, but I can go back over them with you now in June, where we could hold a contested hearing. But how long would you need to select one with Ms. Hardy?
I previously conferred with Cimerex about potential dates in June, and Cimerex is available June 6th or June 20th.
And Freya, you said that our June docket is 13 and 27?
Correct.
But you also said that June 20 is not available, is that right?
For a special hearing, right?
Perfect. So the 6th. So the 6th is available.
It is.
Okay, very good. Ms. Hardy?
The 6th actually does work
Oh,
for
excellent.
COG. I
All
had
right.
conferred with my witnesses as well.
Then we will issue a pre-hearing order for June 6th. It'll be in person here in Pecos Hall. Your witnesses can be available virtually. They don't have to come in person. How many witnesses do you expect?
We will definitely have 2. It's possible we would have 3,
Okay.
but I think 2.
And Ms. Bennett?
Same, definitely 2, but potentially 3.
And now I've noticed something in the pre-hearing statements. I noticed that when we issue a pre-hearing order, and I'm doing this from memory, so I might not get this exactly right, but when we issue a pre-hearing order, we tell the parties that we want to have certain information submitted in advance of the hearing, and I have not seen that complied with in this respect, and that is, what are the issues? What are the specific issues that we need to collect evidence in regards to? Is that, Ms. Hardy, is that something that has typically not been complied with, even though it's on the pre-hearing order?
I think we do submit with
Okay.
our pre-hearing statement a week before the hearing, a list of the issues.
Okay, Ms. Bennett?
I agree with Ms. Hardy. They could be buried a little bit in the pre-hearing statements, which is perhaps something we could clarify. But I do know in the past, for the past couple of contested hearings that I've submitted pre-hearing statements for, I have included a list of issues to be decided. We don't often have agreement on issues that are stipulated. And so that's usually not filled, not identified.
Okay, I understand. Thank you. That clarifies it. I think if you look carefully at the pre-hearing order, the list of items that we need before we go to the contested hearing is important, and maybe you could outline them a little bit more clearly in your pre-hearing statement that you file. Okay, thank you.
Sure.
Thanks for clarifying that. Okay, so we are going to issue so Freya, will you issue a pre-hearing order for this? Now we are talking about cases 24320 and 21. Is that correct?
Correct.
Those 2 cases, right?
That's right.
Just want to make sure.
Yes.
So Freya, will you issue a pre-hearing order in case numbers 24320 and 24321, setting a contested hearing to begin at 9 a.m. on June 6th,
Yes, I will.
here in person? Thank you. I am now calling Matador cases 24324 and 24325. No, I'm not calling these cases. These cases were already called, and they're already going to be consolidated with Mewborn's cases, so not calling those cases. Okay, let's go to Marathon Oil Permian 24336. And I think it's a standalone case. Entries of appearance, please.
Good morning, Mr. Examiner. Dina Bennett on behalf of Marathon Oil Permian LLC.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador Production Company.
Morning, Mr. Examiner. Blake Jones with Steptoe & Johnson on behalf of Northern Oil and Gas.
Good morning, Mr. Jones. Okay. Mr. Jones, did you file an objection?
We did not.
Ms. Vance?
We did, but we have since withdrawn that.
Are we going to hearing?
Mr. Examiner, I wish we could, but I had not filed, given MRC's objection, I had not filed a pre-hearing statement in this case. And so we would ask that this case be continued to May 16th for an uncontested hearing.
Perfect. Any objections?
None from Matador.
None from Northern.
Perfect. So we will, once Ms. Bennett files the proper continuance, we will set this for a hearing by affidavit on May 16. Anything else?
No, thank you.
Excellent. Thank you. I'm now calling 22947 EOG Resources. It looks like we're having a hearing by affidavit.
That's correct, Mr. Hearing Examiner. Paula Vance on behalf of the applicant, EOG Resources.
Are there any other parties entering an appearance?
Good morning, Michael Rodriguez with Civitas Permian Operating LLC.
Are there any objections to this proceeding?
No objections, we're just monitoring.
Monitoring. Okay. And have you reviewed the exhibits?
Yes,
You have. And will you have any objections to admitting those exhibits into evidence?
no, we do not.
Okay, very good. Are there any other parties, Ms. Vance, that you know of?
Yes, I think that they're sitting up here.
Mr. Examiner, Jim Bruce, representing, I can't even read my own notes.
Matador?
Matador, no objection to the matter proceeding by affidavit.
And have you reviewed the exhibits?
Yes, the exhibits are fine.
The exhibits are, okay, very good. Ms. Vance?
Oh, good morning.
Oh, excuse me.
Mr. Examiner, Dina Bennett on behalf of Marathon Oil Permian LLC. And in looking through the case files yesterday, when I didn't see Marathon on the docket sheet, I looked back through the case files, and although Marathon has been treated as a party in this case by the other parties, I had not formally entered an appearance yet. And that's likely because I had entered an appearance in the competing case that has now been dismissed. So long story short, I would like to enter my appearance on behalf of Marathon Oil Permian LLC in this case. Thank you.
And have you, you said you reviewed the case file. Did you look at the exhibits?
Yes, I did, and no objections to the exhibits.
No objections. Okay, unless there's any other parties that are going to pop up. Ms. Vance?
Thank you, Mr. Hearing Examiner. So in case 22947, EOG seeks to pool the uncommitted interest in the Bone Spring Formation, and that is the pool is the Red Hills Bone Spring North Pool, and the pool code is 96434, and that's underlying a standard 640 acre, more or less horizontal well spacing unit comprised of the east half of sections 23 and 26, Township 24 South, Range 34 East, and that's in Lee County, New Mexico. EOG seeks to initially dedicate the spacing unit to the proposed Grackle 26 East FedCom 101H, 102H, 103H, 301H, 302H, 303H, 304H, and 305H. And I would note that the 102H and the 303H are proximity wells, and we've noted that in the compulsory pooling checklist. In this case, we have included a copy of the application, provided the compulsory pooling checklist, as well as the self-affirm statements of Landman Stacy Stretcher and Tara George, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. Ms. Stretcher's statement is Exhibit C and includes all of the required landman exhibits. I won't go through all of them, but I will point out two pieces of detail. One, although it wasn't a part of the original application, approval for the overlap, there is an overlap, and we did provide as Exhibit C1 a diagram showing the proposed spacing unit in relation to the existing spacing unit, along with including a sample letter of the overlapping notice that went out. And then I also wanted to note that the well names are being changed. And so originally under the proposal, they were the Grackle 23. They are now the Grackle 26. We did send out amended proposals and included those updated names. And then moving on is Ms. George's statement, which is Exhibit D, and includes all of the required geology exhibits. In this case, Ms. George did not observe any faulting pinch-outs or other geologic impediments to the horizontal drilling of these wells. And then lastly is Exhibit E, my self-affirmed statement of notice with two sample letters. And I did have some email communication with Freya yesterday regarding the notice. So just to clarify on that, we did provide updated notice in March. And so we included a copy of that notice. We included a copy of the two letters that went out and were timely mailed on March 15th, 2024, and then March 20th, 2024. And then the mailing reports are also included for both sets of those mailings. This is followed by the last exhibit, which is Exhibit F.
Ms. Vance, can I stop you for a moment?
Sure.
On page 64 of your PDF, you have a March 20th letter, which you just discussed now. You said you said both letters were timely, the March 15 letter and the March 20th letter. How is the March 20th letter timely?
Got it. Understood. I just realized, well, am I going back? I'd have to look at my date calculator, but if it is, and I can follow up on this, let me see. Those two parties, we have previously provided notice to them, and obviously Marathon's representation is right here. But we did provide previous notification to these parties, which I can supplement the record with. These applications were originally filed in 2022, and so notice has gone out. We just provided updated notice of the hearing and the amended proposal, and that's why that was I overlooked that on my side. But we did provide notice to both of those parties timely.
Okay. Well, Mr. McClure will, I'm sure, ask you questions about that. So why don't you finish your presentation, and then we'll go to him. We'll deal with the exhibits first, and then we'll go to Mr. McClure.
Absolutely. So the last exhibit is Exhibit F, which is the notice of publication, which was timely published on March 19th, 2024. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record.
Before we deal with the exhibits, Ms. Vance, is it not? That's okay.
One moment, and
Yeah.
that was an oversight on my part. I said Stacy, it is Lacey Stretcher.
For proper notice, you need how many days?
For letter notice, it's 20 business days from the date of the hearing.
20 business days.
Huh? 20 calendar days. Sorry, that's my fault.
That's right. I figured. Okay.
I was blending both NOP and letter notice.
And when you're counting days, you don't count the first day. Is that correct?
Correct.
Okay, very good. So today is April 4. Will you look at your calendar and tell me when is the last day that would have satisfied the 20-day calendar period for notice?
Okay, I see what you're saying. And again, that was an oversight on my part. We have provided a number of different notices, and I can supplement the record with all of the notice that we provided in this.
Just if you would, I understand. Just if you would tell me what is the date?
So it would have been the 15th of last month.
Fine.
Yeah.
So you're saying that if you mailed out a notice on the 15th to a party, that would give them 20 days for today's hearing?
That's correct.
Okay, very good.
Yeah.
So we don't count the first day.
Correct.
Right, okay. So then we're saying if you mailed it on the 15th, it would be, okay, so the 20th day can be the day of the hearing by your understanding of the law.
That's correct, from the 15th.
Okay, very good. Just wanted to clarify that and also for Mr. McClure, because he's listening. Okay. So let's deal with your exhibits first, and then we'll go to your witnesses and Mr. McClure. So I have your exhibits, tab A, B, C, D, E, and F. Are there any objections to it? Well, I've already asked the parties if there are any objections, but are there any other objections? Not hearing any. We are admitting your tabs A, B, C, D, E, and F and their subparts. Mr. McClure, do you have questions for Ms. Vance or her witnesses?
Yes, I do, Mr. Hearing Examiner. I have questions from Ms. Vance in regards to notice, of course.
Please.
Thank you. Ms. Vance, have you submitted, I see this case obviously has numerous submissions from 2022 and onward within this paperwork that's already been, or these documents, which has already been submitted to the division. Does any of this include the notice that was provided to these two additional persons?
To the two additional persons, yes, or not in the, I'm not sure in the record. I would have to look at it. I don't believe so because I believe this is, I think this is our first hearing packet that we've submitted. But again, we provided notice when this was originally filed, and that's just an oversight on my part that we didn't include it. We just provided this supplemental notice that we did with an updated list of the parties. So if I can tell you.
Hold on one second. So before Mr. McClure continues, Ms. Vance, I think what Mr. McClure is asking you is, in all of your previous notices, have you noticed the two new parties that you were noticing on March 20th?
I believe so, and I'm pulling up my files to double
Let's take a
check.
5-minute break.
Sure.
Let's just take a 5-minute break so you don't feel like you're under the gun. Mr. McClure, is that okay with you?
Yes, absolutely.
All right. Freya, why don't you just keep the recorder going?
Okay, will do.
Okay, thank you. It is 9:45 on April 4. We're back on the record. I don't know, I see Ms. Vance looking at her computer, so I'm not sure she's found the information she wants.
Well, I haven't, I've found our original notice list, which has all of the parties. I have asked my legal assistant to send me the original notice letter that went out, the mailing report, and the original NOP. So I would ask that to just recess. I will be here anyway, and just wait until until I get it and I can let the division know.
Mr. McClure, I'm sure you have more questions, so let's leave that question unanswered for now. And then we can, when you're done with your questions, if we don't have an answer, we can recess the case and come back to it after she gets the information she needs. So please proceed with your questions.
Mr. Hearing Examiner, actually, this is the only question I have. If I may, though, I think my recommendation for this case is if we're not able to have something submitted to the record by the end of the hearing, maybe to actually continue it until we have something submitted in writing from the applicant.
Okay. So Ms. Vance, if we don't get the information, if you don't get the information you need by the end of all the cases today, then we'll just continue your case to the next docket and we'll just collect the evidence at that point.
That's fine. Hopefully we'll get it before then, though.
Hopefully we will. So, okay, so Mr. McClure doesn't have any more questions for you, so we will be in recess on that case. I'm just going to take some notes so I don't forget what's going on here. I am now calling Mewbourne Oil cases. There are several of them consolidated, 240, 48, 49, 50, and 51.
Mr. Examiner, Jim Bruce, representing Mewbourne.
Very good. Are there any other parties, Mr. Bruce?
No, sir.
Okay, very good. Please proceed.
Mr. Examiner, these 4 cases were consolidated and presented 2 weeks ago. They were continued because the publication period had not expired. And that has now expired, so that's not an issue.
Okay, Mr. Bruce, let me check my notes from that. It's March 21st hearing, is that right?
Yes, sir.
Let me check my notes.
Sure, it might have been the first March hearing. I can't remember. Let me see.
All right, I found my March 21st notes. So there we go. Let me find. And the case number is 24048, Mr. Bruce?
Through
51.
24051.
Okay, I found my notes. I have that we were waiting to today to cure notice defect in Exhibit 4 in all 4 cases. Is that what you show as well?
The Exhibit 5, the affidavit of publication.
I have Exhibit 4 here for some reason. Did you change exhibit numbers?
No, I did not.
Okay. And I actually have a different issue for 2 other cases. So let's deal with these cases individually. 24048. Let me go to Mr. McClure for a moment. Mr. McClure, was the notice defect that you saw, was it in Exhibit 4 or Exhibit 5?
Mr. Hearing Examiner, it was in Exhibit 3B is the confirmation I'm asking for, and 3A, excuse me, both of those.
Okay, so not Exhibit 4 at all.
Yeah, Exhibit 4 looks like it's his public notice, so I'm wondering if Mr. Bruce may have his exhibits, remembering his exhibits incorrectly.
Okay, so Mr. Bruce,
I apologize. I have two different sets and I'll get into
Sure.
that in a minute. Yes, there's a different numbering system because in 24048 and 24050, those were reopened cases. And so the numbering of the exhibits is different and you're correct.
so Exhibit 4 was the issue.
It is, yes.
Okay, and just to put it on the record, what was the issue and how has it been cured?
The notice was published one day late, so there was only 9 days between the publication date and the hearing date.
And there needs to be 10?
Needs to be 10.
Okay, very good. Now, that obviously has been cured since we're here 2 weeks later. And then you have your landman, Mr. Cullen, present?
Yes, both the landman and geologist should be here.
So, Mr. McClure, just on this one case alone, 24048, now that you know that the publication notice has been cured in Exhibit 4, what questions do you have for Mr. Bruce or his witnesses?
Thank you, Mr. Hearing Examiner. Mr. Bruce, can you please clarify? Can you please clarify for me when written notice was provided for this case?
Written notice was sent to the working interest owners December 13, 2023. And as to, I needed to send additional notice to two parties regarding the overlapping well units, to interest owners, and that was mailed out February 29, 2024.
Thank you, Mr. Bruce. That was the only question I had in regards to notice.
May we take this case under advisement?
I do have additional questions, Mr. Hearing Examiner, just not related to notice.
Oh, go ahead, please.
Yes, sir. Mr. Bruce, what is the current status of the wells proposed under this pooling order?
I'll turn it over to my witnesses, but I believe that most of them have been drilled.
Okay, hold on a second. Which witness are you directing this question to, Mr. Bruce?
Probably, well, both the geologist Carson Cullen and the geologist Tyler Hill.
Okay, and they're both present. So would you please turn on your cameras and unmute yourself? We're going to get you sworn in. Okay, I see one person. Mr. Bruce, do you know who that is?
Good morning, Mr. Examiner. My name is Tyler Hill, and I'm the geologist representing Mewburn in this case.
Okay, very good, Mr. Hill. Do we have Mr. Cullen as well?
Can you hear me? I'm here.
Only barely.
Okay. Try to get closer to the microphone. I haven't done it from my office computer. Also have trouble with the camera. Is the audio any better?
Okay, Mr. Cullen, are you're saying you can't turn on your camera?
Giving it an attempt.
I can see you.
Okay.
Okay, so gentlemen, please speak loudly and speak close to the microphone because we are relying on this WebEx recording to preserve this hearing until it can be transcribed by a court reporter. So gentlemen, please both raise your right hands. Mr. Cullen, I can't see your hand. Thank you, sir. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, or nothing but the truth?
Yes.
Okay. Mr. Cullen?
I do.
Okay, very good. So let me first get you both to state and spell your names for the record. Let's start with you, Mr. Cullen.
Carson Cullen, CarsonCullen.
Okay, and Mr. Hill?
Tyler Hill, Tylerhill.
Okay. Mr. McClure, which witness do you want to direct your question to?
I guess to be honest, I'm not sure which one would have the best answer in regards to the status of the wells, whether that be
Okay,
the
then
landman
let's-
or the geologist.
Okay, then let's treat them as a panel. Mr. Hill and Mr. Cullen, we're going to treat you as a panel. If one of you wants to answer this question, would you please begin?
Mr. Examiner, and Mr. McClure, the wells are producing.
Mr. Hill, do you know approximately when they started producing?
I don't have that data in front of me. I'm sorry.
Pull it up. Give me just a second. July of 2022, approximately.
Okay, thank you, Mr. Collin. Is that in regards to the wells under both case 24048 and case 24050, or which one specifically?
Both, yes, sir.
Okay, thank you. No more questions. Thank you, Mr. Hearing Examiner.
Okay, so Mr. McClure, are you finished asking all of your questions for case number 24048?
I have no further questions. However, I would like the applicant to submit an additional document.
Okay, what document?
Let me bring it up. Actually, if I may ask a question in regards to it. Mr. Collin, was there only one additional person being force pulled?
Yes, sir.
All right, the additional document I'd like to see is for that to be more clearly indicated. I believe there's a letter in the file, but it would be nice if we had an actual table that demonstrated to us which persons are being pulled and stating as such.
Yes, sir.
Okay, Mr. Bruce, do you understand the additional document that we need?
Yes, I did address it at the prior hearing, but I will file a document.
What do you mean you addressed it?
What's that?
I'm sorry, I didn't understand your response. What did you mean you addressed it at the previous hearing?
Well, let me see. I'm looking at, now this is in the next case. I can't file my But if you go to the landman's testimony, there's a plat that shows the interest being pooled, Exhibit 2B.
But it's not in this case. Is that what you're saying?
I thought I filed them in all cases, but I can't recall right now.
So, Mr. McClure,
If you go to the next case, all of the cases only pooled the Boys Club of America, who owned a very small unleased working interest.
Mr. Bruce, I'm going to ask you to stop for just a minute.
Sure.
So, Mr. McClure, you've looked through all the exhibits and you do not see what you need in this case. Is that correct?
That is correct.
All right, very good. So if we give Mr. Bruce a deadline of, let's say, tomorrow by close of business to file that document, and he does file the document, and Mr. Bruce, Mr. Bruce?
Yes.
I want to make sure you understand. So when you file this additional exhibit, please file the entire packet again.
Yes.
Call it an amended packet. Attach a cover letter that says what you are adding so that the technical review knows exactly why you filed that amended exhibit packet. Okay, so Mr. McClure, if Mr. Bruce complies with that order, can we take this case under advisement?
Yes, Mr. Hearing Examiner, I believe we can.
Okay, then I'm going to put notes in this case, and Mr. Bruce, we're going to ask you to move on to case number 24049, and I have different notes for that case, so let me tell you what I show. Are you ready?
Yes.
I show that you are going to file, or that you were going to file, an amended exhibit packet because exhibit 2D was missing. Is that correct?
That is correct.
And did you file the amended packet?
Yes.
Okay, good. And it has let me look at it so we can get exhibit 2D entered.
Yeah.
So this is a continuation of the hearing that began 2 weeks ago. Is that right?
Yes, correct.
Okay, very good. Give me 1 second here.
Yeah, and look at the green packet.
I will, but give me a minute so I can make my notes, or else I'll just be lost. Mr. Bruce, what are you going to call this exhibit in case 24048? What are you going to call it? A table?
Look at it. It's a there's 2 pages really. I think on all of them it should have been called 2B. Certainly in this case it is. It's 2B, which is just a sheet that shows the interest ownership and the party to be pooled, which is the Boys Club of America.
Okay.
And then Exhibit 2C is a summary of communications with that single party.
So exhibits 2B and 2C will be amended.
Yeah. For 2 of the cases they were. I may not have done it for.
We're only talking about 1 case. I don't want to.
Okay.
I don't want to cloud.
24049.
No, we're only talking about 24048 right now.
Okay, that's why I was confused.
That's okay.
I didn't, for some reason, I didn't pick up the exhibit package for that case. I will look at it. If it's not in there, I will refile by tomorrow, close of business.
But the exhibits being corrected or amended will be 2B and 2C?
Yes.
Both?
Just simply 2B.
Fine, that's what I'm asking. Okay, I have a note. Now we're moving on to 24049, and I read you my note from that case, and you filed an amended exhibit. I just wanted to look at it so that Mr. McClure isn't the only one who can see it. 24049. 24049. Okay, let me look here. And you said, look at the green one. Look at the green one. Yes, I see a green exhibit packet. And we talked about exhibit 2B as in boy, summary of interest. Is that correct?
That is
Very
correct.
good. I do see it here. So we need to get that entered into evidence because it wasn't in the original packet. Is that right?
Correct.
Okay, very good. Do you want to make a motion for that?
Yeah, I'd move the admission. You were correct, by the way. Exhibits 2B and 2C should be admitted into the record.
Very good. Are there any objections? Not hearing any exhibits 2B and 2C of the amended exhibit packet filed on, it looks like March 22nd on or about, are hereby admitted into evidence. Mr. McClure, do you have any questions on this case?
Yes, I do, Mr. Hearing Examiner.
Mr. Bruce, do you have any, your witnesses available? The same two. Very good. Mr. McClure.
Okay, I believe Mr. Bruce is the one to address this too because it's of notice.
Go right ahead.
Mr. Bruce, please
Yes.
confirm for me the date that written notice was provided of this case.
Sure. And I've got one more thing to bring up, Mr. Examiner, after this.
But just answer the question first and then we'll deal with any of
Once again, notice of this case was sent out. Notice to the working interest owner being pooled was sent out December 13, 2023. And then for the overlapping well units, it was sent out February 29, 2024.
Thank you, Mr. Bruce. Thank you, Mr. Hearing Examiner. No further questions.
Okay, and Mr. Bruce, you had another issue?
Yeah, also in your notes, it should show that I had neglected to stuff the AFE in the exhibit package, and that is exhibit 2D, so I'd move the admission of that exhibit.
Are there any objections? Exhibit 2D, as in David, is now admitted into evidence. Does that conclude your case, Mr. Bruce?
Yes, sir.
Okay, good. Can we take this case under advisement, Mr. McClure?
Yes, we can, Mr. Hearing Examiner.
Okay, this case is taken under advisement, as is 24048, as long as you file the proper documents by close of business tomorrow in 24048. Let's move on to 24050. This I have the same note as I did in 24048, so I won't go back over that note again. So we had the Exhibit 4 notice issue, and you have your witnesses available. Are there any additional exhibits in 24050 that need to be admitted?
What I would say is that the exhibits 2B and 2C that you wanted me to in 24048.
Yes.
I will submit a revised exhibit package containing what you requested.
For the new case we're calling now, which is 24050.
Correct.
Okay, very good. And your witnesses are available. Mr. McClure, are there any questions in 24050?
Yes, I do, Mr. Hearing Examiner.
Please proceed.
Yes, sir. Mr. Collin, just to bring into this case as well, can you please confirm for me that at least one well that's a part of case 24050 was producing in the year of 2022?
Yes, I can.
And approximately what month was that?
July.
July of what year?
2022.
Thank you.
Mr. Collin, was there only one additional person being force pulled?
Yes, sir.
Okay, thank you, sir. Mr. Bruce, if we could submit this same exhibit that was referenced for case 24048 for 24050 as well, that being a table or list of pulled persons, clearly identifying who was being force pulled. and their interest.
I will do that.
Okay, thank you, sir. Thank you, Mr. Hearing Examiner. I have no further questions. Oh, excuse me. Let me back up 2 seconds. I do have one additional question. Mr. Bruce, can you confirm for me when written notice was provided for this case?
It was the same as, I sent out the same notice on all 4 cases. So last December 13th for the working interest owner, and then February 29th for the notice of the overlapping well units.
Okay, thank you, Mr. Bruce. Thank you, Mr. Hearing Examiner. I have no further questions on this case.
Okay, so Mr. Bruce, just like 24048, 24050 is taken under advisement as long as you file the amended exhibit packet to include a table of the persons being pooled, which is a corrected 2B and a corrected 2C, as you mentioned before.
Correct.
Okay, very good. Now we're on your last case, Mr. Bruce, at least in this group of cases. It's 24051.
Yes, sir. And again, this case is like 24049. The 1 day lapse in the notice that has been cured. And and the written notice was the same. Publication period has now expired, so that's fine. And so, I'd move the admission of exhibits 2B, 2C, and 2D.
In your amended exhibit packet.
Correct.
Are there any objections? Not hearing any exhibits 2B, 2C, and 2D in the amended exhibit packet are now admitted into evidence in case number 24051. Mr. McClure, do you have any questions?
Yes, I do, Mr. Hearing Examiner.
Please.
Mr. Bruce, can you please confirm for me when written notice was provided for this case?
Again, December 13, 2023 to the Boys Club of America, the working interest owner, and February 29, 2024 regarding the overlapping well units.
Okay, Mr. Bruce, I'm also going to need a amended pooling checklist submitted for this case. Let me very quickly finish my notes for the last case though, and I'll get you what I'm needing.
Oops.
Actually, I have a very fast question for you as well, Mr. Bruce. On your pooling checklist, within the category formation and pool for well location, setback, and rules, you state that it's Purple Sage and statewide rules. Can you clarify your reference to statewide rules there?
I just pretty much throw that on everyone just to know that it's the statewide horizontal rules as modified by the Purple Sage pool. I mean, but if it's setbacks you're looking at, of course, it's 330-foot setbacks in the Purple Sage. And
absolutely. Oh, go ahead.
Yeah.
I'm sorry, sir. Continue.
And if you want me to amend this to exclude the statewide rules and throw in the 330, I can certainly do that.
Yes, that is one of the corrections. In addition to that, you referenced the building blocks as 40-acre building
Oh.
blocks.
I wish I had the same mistake detector you have, Mr. McClure.
And is your intention to correct that to 160-acre building blocks?
I think the building blocks would be, well, whatever you desire, 160 or 320.
Yeah, I was gonna say, I know there's definitely discussion in regards to the 160 versus 320. And at your discretion, you may submit in that field 160 or 320 at your discretion, or include both. That's fine. But please, when you submit us an amended pooling checklist, if you could please correct that box as well.
I will, what I'll do is I will, right underneath the cover sheet, I will submit a little letter stating what I am correcting.
I think that is correct with what we want. Is that correct, Mr. Hearing Examiner?
I think so.
Described it. Okay.
I think so.
Hey, thank you, Mr. Bruce. Mr. Hearing Examiner, I have no further questions.
Okay, so we will take this case under advisement as long as we receive the amended hearing packet by close of business tomorrow. Is that acceptable?
Thank you.
Okay, thank you, Mr. Bruce. We're going to move on now to case number 34 on our docket, which is Silverback Operating LLC, their amendment to existing order 22655. It is case number 24281. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shield, appearing on behalf of Silverback Operating 2 LLC.
Are there any other parties, Mr. Savage?
I don't believe there is.
Okay, please proceed.
Silverback would like, so we would like to consolidate this case with number 35, and that's 24282.
Okay, so I'll call that case as well, 24282. Please proceed.
Okay, and these involve two adjacent units. And the exhibits in the hearing packet are arranged and presented in similar fashion. So I think it'd be most efficient if I kind of go through them concurrently. So in case 24281, Silverback seeks to reopen case number 23315 and amend order R22655 in order to request a 1-year extension of the well commencement deadline for the pooled unit in the Yeso formation underlying the north half, south half of section 22, township 18 south, range 26 east, Eddy County, New Mexico, as it pertains to certain Krause wells. And likewise, in case 24282, Silverback seeks to reopen case number 23316 and amend order R22671 in order to request a 1-year extension of the commencement deadline for the pooled unit, again in the Yeso formation, and this underlines the adjacent unit, south half of section 22, as it pertains again to certain Krause wells. The original pooling orders, copies of which are provided in the reference section of the 2 hearing packets, allow for a time extension upon showing of good cause. And in each exhibit A of the hearing packets, landman Mr. Jake Biebermeyer, who is available today, is familiar with the subject lands and units and whose credentials have been previously accepted as an expert witness. He testifies that Silverback is in good standing under the statewide rules and existing pooling orders, and there is good cause to grant the time extension requested. Mr. Biebermeyer states that Silverback has made substantial progress towards developing the administrative foundation for operations of the units since the issuance of the original orders. They have pursued due diligence regarding new owners recently discovered, and they have repooled those. And while finalizing the administrative requirements, Silverback has worked to schedule drilling rigs for the units, but has experienced certain operational matters and unanticipated delays in securing the rigs. Silverback respectfully requests the opportunity to move forward without interruption under a 1-year extension, extending the drilling commencement date to April 29th, 2025 for each unit. The mailing reports and the self-affirmed statements for notice in each Exhibit B of the hearing packets show that notice of these cases was timely. The notice letters were timely mailed to the pooled interest owners, and notice and the Carlsbad current Argus was timely published to account for any unlocatable parties or contingencies in notice. At this time, I requested Exhibits A and B and all sub-exhibits in cases 24281 and 24282 be admitted into the record, and that the two cases be taken under advisement. And I'm available to respond to any questions, as well as Mr. Biebermeyer, who is available online.
Okay, are there any objections? Not hearing any exhibits under tab 1, 2, and 3, which include other items besides Exhibit A and B, are admitted into evidence in both cases. Mr. McClure.
Mr. Hearing Examiner, I have no questions for either of these cases.
Okay, Mr. Savage will take these two cases under advisement. Thank you.
All right, thank you.
Okay, let's move on. Two 24283, Devon Energy Production, compulsory pooling application.
Good morning again, Mr. Hearing Examiner, Mr. Technical Examiner. Darren Savage with Abity and Schill, appearing on behalf of Devon Energy Production Company, LP.
Are there any other parties in this case?
I do not believe so.
Okay, please proceed.
Case 24283. This case covers lands in sections 1, 2, and 3, Township 21 South, Range 27 East, Eddy County, New Mexico. I'd like to point out that this case is the companion case to the case number 24250, heard March 21st and taken under advisement, in which Devon sought an order pooling the Bone Spring Formation for the same subject lands. The landman, Andy Bennett, for this case, 24283, has testified before the division as an expert witness, and his credentials have been accepted as a matter of record. And the geologist, too, Joe Dixon, has also testified previously by affidavit, and his credentials have been accepted as an expert witness. In case number 24283, Devon seeks an order pooling all uncommitted interest in the Wolfcamp Formation, designated as an oil pool underlying a non-standard 1,920 acre, more or less, spacing unit covering lots 9 through lot 16 and the south half of sections 1, 2, and 3. The proposed unit is dedicated to 4 initial wells, and these are the Burton Flat 3-1 Fed State Com wells, which include 623H, 624H, 626H, and 826H wells. The proposed unit is non-standard, and Devon has submitted an administrative application, and that was submitted on March 5th for approval of this non-standard unit. Mr. Bennett's exhibits include his landman self-affirmed statement, the C-102's ownership breakdown with a list of parties to be pooled, and the well proposal letter and AFEs, and the chronology of contacts. And I'd like to point out that background and procedural history of the pooling applications is described in paragraph 5 of the landman statement for your convenience. Mr. Dixon's Exhibit B includes his self-affirmed statement, along with the 5 standard geology exhibits, B1 through B5, showing the potential for development as described in his statement. And Exhibit C provides a self-affirmed statement of notice for mailings and the publication notice. Notice was timely, mailed. All working interest owners were located and were locatable and sent notice. And for some unknown reason, the notice letter for Magnum Hunter Production was reported as to be returned. It was delivered in the sister case, and Devon has been in close communication with Magnum, and the parties have entered the JOA, so they are no longer being pooled. Of the numerous overriding royalty interest owners, 3 letters are reported as to be returned, and 6 letters are listed as in transit. Service of notice by publication was timely to account for any unlocatable parties and contingencies. Regarding notice, Mr. Hearing Examiner, at this time, I move that Exhibits A, B, and C and all sub-exhibits be admitted into the record for case 24283, and that this case be taken under advisement. I myself am available for questions, as well as Mr. Bennett and Mr. Dixon, who are available online. Thank you.
Thank you, Mr. Savage. Any objections to these exhibits? Hearing none, they're admitted into evidence, tabs 1, 2, 3, and 4. Mr. McClure?
Thank you, Mr. Hearing Examiner. I do have some questions, most likely for both Mr. Savage and at least one of his witnesses.
Okay, let's get the witnesses sworn in. Do we have Mr. Bennett and Mr. Dixon available?
This is Andy Bennett.
Mr. Hearing Examiner, we should.
I see. Yeah, I see Mr. Bennett. I think I see Mr. Dixon as well. So gentlemen, will you please raise your right hands? Thank you. Is the testimony do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, good. Would you please state and spell your names for the record?
Andy Bennett, ANDYBENNETT.
Thank you.
Joseph Dixon, JOSEPH DIXON.
Okay, and Mr. Savage, do you agree to have your witnesses sit as a panel for the questions?
Yes, I do. Thank you.
Very good. Mr. McClure, ask your question, and whoever on the panel feels more comfortable answering it can just answer it.
Thank you, Mr. Hearing Examiner. And definitely the witnesses may be able to answer the question that may be more legal in regards. I'll ask the more legal one first, or maybe some initial questions in regards to it. Mr. Bennett or Mr. Dixon, the division has already heard cases 23910 and case 23911 in the past, and I believe orders have been issued for both of these. What is Devin's intent towards those pulling orders?
The intent would be to eventually dismiss those orders if and when this current case is approved with a new order. And Darren, feel free to chime in if that's not the legal correct answer.
That is correct, and I believe that would be appropriate procedurally under the rules.
And is Devin making that request a part of this? I hadn't seen it in writing, I guess, as such.
Mr. McClure, yes, I believe it's definitely in the written testimony where we describe it, and that's paragraph 5 and thereabouts in that. And I believe we also included some procedural history in the application itself. I think we expressed that, but we do have the procedural history in there, but we do express the intent in the testimony.
Can you please direct me to that, Mr.
Okay.
Savage?
Well, first, let's look at paragraph 5 of Mr. Bennett's written testimony.
Mr. Savage, can we have a page number in the PDF?
Yes. Trying to navigate through here on my laptop. So his written statement begins on page 13, and then paragraph 5 is page 14. And we discuss previously pooled orders, and then we point out there are legal descriptions, and we point out the orders, the cases and the orders involved. In this application, it's part of the process to reconfigure the 2 existing units into a larger non-standard unit, a process which also included us seeking approval by filing an administrative application, which is filed concurrently. And I thought we had specifically expressed the intent. It may be elsewhere in here, but that is the context for that, and that's our intent.
Okay, Mr. Savage.
If we can go to the application, and that's page 4. And it's paragraph 2. We also give the procedural history, and it's part of the process to make a transition to the larger non-standard unit, at which time once approved and order issued, we would dismiss the previous orders.
So, Mr. Savage, nowhere in here do I see the word dismiss or
Apparently not.
something of that intent. So, Mr. McClure, do you need something to be amended and resubmitted to say that?
I think verbal testimony here will probably be sufficient for the division to go ahead and dismiss the prior cases when this one is ordered, if you feel that's appropriate, Mr. Hearing Examiner.
So is it dismissing cases or is it vacating orders, Mr. Savage? What is it?
So I'm always overly cautious. So I would dismiss and terminate both the order and the case.
You don't have the power to dismiss the order, do you?
I request a motion to.
And who would you file that motion with?
I would file it with the division.
With the division examiners or with the hearing division?
You know, I would submit it as if I were submitting any other pleading, and I would do it as a motion to the division to request that it be dismissed and describe the circumstances under which it would be dismissed.
Okay. And Mr. McClure, do you have any, well, Mr. Savage, do you have historical knowledge of doing that?
Yeah, I'm trying to think. You know, most of the time we request a dismissal because we realize we want to change something before the order is issued, and we would request a dismissal and do an amended application. But the way this chronologically fell out, this was the only means of doing this.
When were the orders issued?
I would have to look that up on the OCD website. Let me see.
Mr. McClure, do you know when these two orders, 23910 and 23021, were issued?
I don't have that in my notes in front of me. I'd also have to look it up.
Right, and I can look it up myself, so that's not an issue. So, Mr. Savage, why don't you file a motion and a proposed order in Word format with the hearing division, so it'll come to me. And what we'll do is once this, as part of the approval that Mr. McClure deals with, we'll get those orders vacated.
I will do that. If I could I do it as a contingency upon, describing it as a contingency upon?
Definitely.
Okay.
Definitely.
Yep, thank you.
Definitely. Mr. McClure, any other questions?
Yes, I do, Mr. Hearing Examiner.
Proceed.
This before our witness board. With the definition that a gas well in front of the division is defined as 100,000 cubic feet of gas per barrel of oil. Do you understand that definition?
Yes.
Yes.
With that consideration, would all four, or let me backtrack. With that definition in mind, what would you classify all four of these wells in regards to oil or gas?
Oil.
I thank you, Mr. Bennett. Mr. Savage, on your pooling checklist, if I may direct your attention to the formation pool area of that pooling checklist, sir.
Yes, sir.
Under pooling this vertical extent, as well as the formation names or vertical extent at the top, you include Wolfcamp Formation, correct?
Generally, yes, that is correct.
In this particular instance, do you agree that the Upper Wolf Camp would be what you're requesting? Pulling of?
I agree. That's a better, more precise description of that. Yes.
Okay, Mr. Savage, if you could please provide us with an amended pulling checklist with both of these corrected to Upper Wolf Camp formation.
We'll definitely do that.
Okay, thank you, Mr. Savage. Thank you, Mr. Hearing Examiner. I have no further questions for this case.
So, Mr. McClure, can we take this case under advisement as long as Mr. Savage submits what you're asking?
Yes, Mr. Hearing Examiner, I believe so.
Okay, so I want to take some notes. Mr. Savage, what are you submitting as an amended exhibit packet in this case?
So we're going to amend the compulsory polling checklist to denote more accurately the Wolfcamp, the vertical extent being the upper Wolfcamp formation. And then we will submit a motion that's contingent upon the order being issued and the other ones being dismissed.
Okay, when can you submit the amended exhibit packet?
Next week, early next week.
Monday, close
Yep.
of business?
Next
April 8th?
week.
Okay. Right, I'm taking notes. Okay, before Mr. Savage will take that case under advisement. Thank you for your
Thank you.
presentation and your witnesses' participation. Before we move to number 37 of the docket, I'd like to take a 5-minute break. It's 10:36. We'll come back on the record at 10:41. Thank you.
Together through that. Yeah. So.
Yeah, these are all good.
Yeah. Oh, I know. Yeah. Yeah, we used to.
All right, it is 10:45 a.m. on April 4th. We're back on the record. I am calling Spur Energy Partners 24285. Entries of appearance, please.
Good morning, Mr. Examiner. Jackie McLean. I'm over here today because I had to plug in my computer on behalf of Spur Energy Partners.
Are there any other parties that you know of?
No, sir.
Okay, and you're proceeding by affidavit?
That's correct.
Please Please proceed.
Thank you. In case number 24285, Spur seeks an order extending the time to commence drilling the Mayaro 22 State Com 10H and 70H wells. And the division issued order number R22618 in case number 23226 on April 13th, 2023. And that order approved a 160-acre standard horizontal spacing unit comprised of the west half, east half of Section 22, Township 17 South, Range 28 East in Eddy County, New Mexico. The order also dedicated the unit to the Mayaro wells and designated Spur as operator of the unit and the wells. And good cause exists to extend the deadline to commence drilling the wells because Spur has been unable to commence drilling due to a force majeure event at the primary gas purchase facility that will connect the wells. So they've just been unable to drill them. And for that reason, Spur requests the division extend the deadline to commence drilling the wells to April 13th, 2025.
All right, Ms. McLean, I have an exhibit list here. I don't know that for an amendment, we need to get all specific on every exhibits. Are you asking to admit exhibits A and B?
Correct.
Okay, have these experts been qualified before?
Yes. Oh, yeah. Well, Mr. Oldest has previously testified.
And is he available for questioning if necessary?
Yes, he should be on there.
Fantastic. So are there any objections to admitting exhibits A and B into evidence? Not hearing any exhibits A and B and their subparts are admitted into evidence. Mr. McClure, any questions for the witnesses?
Mr. Hearing Examiner, I have no questions for this case.
That's what I thought. Okay, excellent. We will take this case under advisement. Thank you, Ms. McLean.
Thank you.
I think in the future for for applications to amend cases, I think we can keep it brief.
Okay. I have a few more, so
Excellent.
I'll keep them very brief.
Let me call the next case. Hold on one second. Okay, do we have Tascosa Energy?
That,
Yes, case number 24298.
yes, Mr. Examiner, Jackie McLean of Hinkle Shaner on behalf of Tascosa Energy Partners.
Are there any other parties?
No, sir.
All right, excellent. Please proceed.
Thank you. This is also an application to amend order number R22741, which was entered by the division on June 7th, 2023. And Tascosa is requesting a 1-year extension to commence drilling due to the need to simultaneously frack the wells in the unit to avoid reservoir damage. And the drilling rig is not available prior to the expiration of this order. So we believe good cause exists to extend the deadline to commence to June 7th, 2025. And we ask that exhibits A and B be submitted into the record and that the case be taken under advisement.
Thank you. Let me open up the exhibit packet. I have in 24298, I have exhibits under A and B. Are there any objections? Not hearing any, they're admitted into evidence. Mr. McClure?
Mr. Hearing Examiner, I have no questions for this case.
Excellent. We'll take this case under advisement. Let me take some notes and we'll move on. I have Permian Resources Operating 24300. Ms. McLean?
Yes, Mr. Examiner, Jackie McLean for Permian Resources and Colgate Production in case numbers 24299 and 24300. They are consolidated for, or we ask that they be consolidated for hearing today.
Will you repeat the case numbers again, please?
I think you just had missed one. It's 24299 and 24300.
You're right, I did miss one. Thank you. Okay, so please proceed.
Thank you. And this is an amendment of an order. However, this one is to pool additional interest owners under the terms of order numbers R23008 and R23009, which the division entered on January 10th, 2024. And in those cases, the orders pooled interest in the Bone Spring Formation and dedicated the unit to the Long John wells. And since those orders have been entered, Colgate has identified additional uncommitted interest in the unit that we would like to have pooled under the terms of this order. And because this is just a reopening to pool additional interest, we just have Exhibit A, which is land testimony of Mason Maxwell, who has previously testified before the division, as well as Exhibit B, the notice testimony. And so I ask that those exhibits be admitted, and that the cases be taken under advisement.
Okay, so I'm going to deal with one case at a time. So we have 24299, Exhibits A and B. Are there any objections? Not hearing any, they're admitted into evidence. Mr. McClure?
Yes, I do have a fast question for this one, Mr. Hearing Examiner.
Do you want to ask, is the question for counsel or is the question for their self-affirmed statement of Mason Maxwell?
It's a possibility that counsel may know the answer to this, but it may be more appropriate for the witness.
Why don't you ask your question to counsel and we'll see if we need to swear in the witness.
Okay, Ms. McLean, if I may direct your attention to page 14 of 31 of the exhibit packet.
Are you for case 24299?
That is correct.
Okay, I'm getting there. Okay, the exhibit A3, the plot and the interest owners?
Yes, that is correct. On your table that has the interest owners, there's still numerous interest owners that is marked as, let me backtrack a little bit. Is everybody on this table that has a Y in the pooling column being pooled?
So the ones that are not highlighted have been previously pooled under the prior orders. The ones that are highlighted in yellow are the additional interests that we're seeking to pool in these two cases, or in this case in particular.
Now in the footnote that is on this same page, it references that the parties to be pooled are highlighted in yellow. Would it be more accurate statement to say that the parties highlighted in yellow are the new persons being pooled?
Yes, I guess we could say that they're the additional parties to be pooled under the terms of the order. But since this is, reopening those prior orders, and I believe in the testimony, let me just go. So this is page 3 of the PDF packet that was submitted. Paragraph 7, it says that it identifies the additional uncommitted interest to be pooled under the terms of the order, which are highlighted in yellow. So I believe that the paragraph 7 and exhibit A3, it's very clear that the parties highlighted in yellow are the additional uncommitted interests that we intend to pool under the terms of the order.
And Ms. McLean, I do agree with you. I did not notice the additional verbiage here in paragraph 7. Thank you, Ms. McLean. Thank you,
You're
Mr.
welcome.
Hearing Examiner. I have no further questions for this
Okay,
case.
we will take case number 24299 under advisement and move on to 24300. Let's get those exhibits into evidence. I have the same general exhibits, A and B. Are there any objections? Not hearing any. Exhibits A and B are admitted into evidence. Mr. McClure, in this case, do you have any questions?
I have no questions, Mr. Hearing Examiner.
Okay, then this case will be taken under advisement, Ms. McLean, as well.
Thank you, Mr.
Thank
Examiner.
you. Let me just take some notes so I don't skip another case. Okay, I am now calling 24301 Permian Resources Operating.
Yes, Jackie McLean for Permian Resources and Colgate Production. In case numbers 24301 and 24302, we ask that these be consolidated for hearing.
Perfect, they're consolidated.
Thank you, Mr. Examiner. This is case numbers 24301 and 24302 are also cases in which Colgate seeks to pull additional interest owners under the terms of prior hearing orders. These are order numbers R23010 and R23011, which were entered by the division on January 10th, 2024. And these orders pulled uncommitted interest in the Bone Spring formations and dedicated the unit to the silver wells. And since the entry of these orders, Colgate has identified additional uncommitted interests in the unit that have not been pulled under the terms of the order, and that we request that these additional interest owners be pulled under the terms of order numbers R2301 and R23011. And the exhibit packets submitted for case numbers 24301 and 24302 are Exhibit A, the land testimony and accompanying exhibits, and then Exhibit B, notice testimony and accompanying exhibits. And I ask that Exhibits A and B be admitted to the record and that these cases be taken under advisement.
Are there any objections? Not hearing any. Exhibits A and B in case numbers 24301 and 24302 are admitted into evidence. And Ms. McLean, it's your representation that Mason Maxwell has testified as an expert.
That's correct,
Thank
Mr. Examiner.
Very good. Well, let's turn to Mr. McClure.
No questions for either of these cases, Mr. Hearing Examiner.
Fantastic. Thank you, Ms. McLean.
Thank you, Mr. Examiner.
Okay, let's go on to case number 24335. It's Oxy USA.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Oxy.
Okay, and do you know of any of the parties who have entered in this case?
No,
Okay, and you're presenting by affidavit today?
that's correct.
And is your witness available?
They should be, but let me just check online because I did email them. Yes,
Very good. What is the witness's name?
I do have Miss Carr on the line and I believe Mr. Roeder.
Okay, wonderful. Go right ahead.
Thank you. Give me just 1 second. All right, so in this case, case number 24335, Oxy seeks an order acknowledging the Olive One Deep Federal Exploratory Unit. The unit area consists of approximately 2,240 acres of all federal lands in Eddy County. Which is, let's see. And in the hearing packet, we have included Exhibit A, which is a copy of the application. With one exhibit, we included the fully executed unit agreement. We've also included Exhibit B, which is the self-affirmed statement of Ms. Carr, who has previously testified before the division, and her credentials have been accepted as a matter of record. Also included as a sub-exhibit is the final approval from the BLM. This is followed by Exhibit C, which is the self-affirmed statement of Mr. Roeder. I'm sorry. I think
Mr. Roundtree?
Mr. Roundtree, I am so sorry. Mr. Roundtree, who has previously testified before the division, and his credentials have been accepted as a matter of record. And included with his included are sub-exhibits, all of the required geology sub-exhibits. We did not include notice because this is completely voluntary, and we do have a completely executed unit agreement as well as approval from the BLM, so notice was not required. So unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case be taken under advisement at this time.
Are there any objections? Not hearing any exhibits A, B, C in case number 24335 are admitted into evidence. Mr. McClure.
Thank you, Mr. Hearing Examiner. I do have one line of questioning for Ms. Vance and another line of questioning for one of her witnesses.
So let's, do you know which witness you want to pose the questions to?
Likely, Mr. Carr would likely have the answer for me.
Do you mean Miss Carr, Courtney Carr?
Oh, Miss Carr. Yeah, excuse me. I didn't.
Okay, no
I
problem.
missed the first name when I was
No
looking at
problem.
the pre-hearing statement.
Why don't you ask your questions to Ms. Vance first, and then we'll get Ms. Carr sworn in, and we'll go from there.
Yes, sir. Ms. Vance. I don't see any indication of notice being conducted for this case. Is that correct?
That's correct. And I already previously stated on the record, because this is completely voluntary and we do have a completely executed unit agreement, which was included with the application and approval from the BLM, final approval from the BLM, no notice was conducted.
I guess if I may direct your attention to page 4 of 293. On paragraph 5 of, I guess this is probably the application packet. There's reference here to after notice and hearing as required by law. Is it your testimony that there is no notice required under law for this case?
In this situation, no. When we applied, we use, language that in some cases may be boilerplate language to cover all bases. But as we are here today at hearing, it is not required.
Okay, thank you. To your understanding, has the BLM already approved this unit then?
That's correct. If you go to exhibit B1, which is page 282 of 293.
Thank you, Ms. Vance. I guess, what is the purpose that Oxy had in bringing this case to the division if the BLM has already approved it?
Well, Mr. McClure, it's our understanding that even though this is 100% federal lands and we do have a completely signed unit agreement and approval from the BLM, that the division still requires some sort of acknowledgement or approval of the unit, and therefore we filed the application.
Is it correct that in prior cases, the reason for filing was because the BLM and or state land office wanted the division to hear it first?
I can't speak to that. Don't know.
I guess, would it be accurate to say that that's definitely not the case here, though, considering that the BLM has already approved the unit?
Can you restate your question?
In this case, is it correct that the BLM did not require this case to be heard before the division prior to approval of the unit?
I am not aware of that, but Ms. Carr may be able to answer that. I'm not sure what the BLM required in terms of coming to hearing today. But again, it's my understanding, and I'm actually going and pulling up, trying to see the notice that was recently sent out by the division, I think a couple months back, regarding the division's jurisdiction, and basically wanting, even in this case, or like in this case where it is all federal lands, that we still are filing with the division because the division has concurrent jurisdiction.
Okay, thank you, Ms. Vance. I'll ask Ms. Carr this question then in regards to the BLM.
So Ms. Carr, will you turn on your camera so we can get you sworn in? Let's see if we can hear you.
I can hear me.
And I can hear you. Would you state and spell your name for the record?
Courtney Carr, COURTNEYCARR.
Would you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And please speak loudly so that the microphone picks up everything you say. Mr. McClure?
Thank you, Mr. Hearing. Thank you, Mr. Hearing Examiner. Ms. Carr, are you aware of whether the BLM asked for this case to be heard before the division?
It's my understanding that the division has to acknowledge this unit. I'm not, I don't know if it was a requirement, but I think we were required to, that the OCD acknowledge that the unit has been formed. I'm not really sure.
I guess let me ask the question a little bit better, I guess. Ms. Carr, did the BLM ask that the division acknowledge the unit?
No, not to my knowledge.
Okay, thank you, Ms. Carr. Okay, Ms. Carr, if I may direct your attention to page 283 of 293, this should be the BLM's approval letter.
Yes.
In paragraph 3 of this approval letter, it states that this will be a divided unit and that the participating areas will only be the drainage for the individual wells. Is that your understanding?
Yes.
Now, if I may draw your attention to Exhibit D of the unit agreement, that's on page 278 of 293.
Yes, I'm there.
Okay, on paragraph 2, it states that the initial participating area will cover, and then it lists off a number or area. Does it appear that this initial participating area would be the entirety of the unit area?
Yes, that's correct.
Mr. McClure, what page are you on again?
Ms. Vance, I'm on page 278. It should be Exhibit D of the unit agreement. May I continue with my question of Ms. Kaur, or let me give you a chance, Ms. Vance, to...
I'm there.
Okay, thank you. I guess, Ms. Kaur, to your understanding, is this the intent for the initial participating area, or is the BLM's approval letter the actual stipulation?
That is, it's both. We came to an agreement with the BLM Reservoir Management Group that the initial participating area would cover the entire unit boundary based on the number of wells that we were drilling and the target formation.
I guess, is it Oxy's intent to then submit an NSP in order to get that spacing unit assigned?
Well, I think at first we would need to do like a commercial well determination. And then once the wells are considered commercial, then they would be assigned a PA per the unit agreement. And then that would be up to the interpretation of the BLM if the wells are considered commercial and assigned the PA as the size of the unit agreement.
Yes, I'm in agreement with that, Ms. Carr. Let me re-ask my question. In order to establish the draining area for the wells that are going to be drilled for this unit, is it Oxy's intent then to submit an NSP to get that spacing unit approved?
Mr. McClure.
I don't know the answer to that question. I would have to defer to my regulatory department.
Can I jump in here? If it's part of the unit, Mr. McClure, I don't believe they'd need to file for an NSP, correct?
That's not correct, Ms. Vance.
Okay, hold on, stop.
Oh, yeah, I'm sorry, Mr. Examiner.
We can't have Mr. McClure answering questions, Ms. Vance. So please don't ask him any questions to that respect. He's asking you a question. And Mr. McClure, did you get the answer you need, or do you need to ask a different question?
I do need to ask a different question just to confirm what I believe my understanding is. And it may be that Ms. Vance can answer this for me, if I may, Mr. Hearing Examiner.
Sure, go ahead.
Ms. Vance, presuming that an NSP were to be required, is that line of questioning fine, Mr. Hearing Examiner?
I'm not sure what you just said. Are you proposing a hypothetical question to Ms. Vance?
Okay, yes, I'll go with that.
Okay,
yes,
you
that's
can do
fine.
that.
Okay, thank you, Mr. Hearing Examiner. Under the presumption that an NSP would be required for these wells to have an HSU assigned to them that takes up the entirety of the unit. Are you still caught up with me, or are you with me, Ms. Vance? Under
I
that
am.
hypothetical? Okay. In that hypothetical, Ms. Vance, would it be Oxy's intent then to submit an NSP in order to get the HSU assigned to the wells?
I would have to confer with my client on that and discuss and look at the rules as well.
So, Mr. McClure, that's the answer to your hypothetical. That's a valid answer. And if you need more information, we can recess this case and we can pick it up on a later docket, giving Ms. Vance time to do what she just said. So, Ms. Vance?
I would just ask to recess so I can discuss with my client,
Okay.
And then provide an answer at the end of the docket.
Fine. And then we have another case of yours recessed as well, Ms. Vance.
Yes, and I'm prepared to go forward with that one whenever you're ready.
Mr. McClure, we're going to recess the case that we're discussing right now. We're going to go back to another case that Ms. Vance asked me to recess since she has the information that we need. Maybe we can take that under advisement after she gives us the information. So what's the case number, Ms. Vance, that we're recalling?
It is case number 22947.
Yes, the one that's several years old.
Yes, that's correct.
Okay, so we're back on the record on 22947. And what do you have to tell us?
Yes, Mr. Hearing Examiner. So I did send to both you and Mr. McClure notice that we did when this case was originally filed. So I have notice, both the letter notice, the NOP, and the tracking information and mailing report that was sent in 2022, and then additional notice that was sent in December 2023. And just looking at the time frame, there was one party, I went and checked and made sure that all of the parties that we have listed as being pooled are included in that, both of those separate notices. And then there was only one new party that we did submit notice to on March 15th, which was timely mailed, and that was to Mr., I think, Kenneth. But all of the notice has been completed, and I think that the division can take this case under advisement at this time.
As long as you file an amended exhibit.
Absolutely. I will do a cover page and submit all the notice.
Okay, so let's go to Mr. McClure. Mr. McClure, I don't know if you've seen these emails and have looked at these documents, or if you need some time to do so.
Mr. Hearing Examiner, I looked at one of them, but I may need a little bit more time to look at the other. But I am prepared to ask Ms. Vance a few questions, I guess, if you'd like me to at this time.
Let's wait until you've had time to review all of these, because there's a bunch of exhibits here, so that you can formulate all your questions at one time. So Ms. Vance, we're going to go back on recess in this case. Thanks for sending the additional information. No matter what happens at the end of today on this docket, how long will you need to submit an amended exhibit packet?
My legal assistant is putting it together. I'll file it this afternoon.
I figured that. Okay. All right. So, okay. So now we are in recess on this case here and on the case we were just dealing with a moment ago. And that case was 24335. So we will come back to 24335 and 22947. So Ms. Vance, will you let me know when you are ready to take back up?
With the Oxy case? Yes.
Yes, okay. So let's move on to Mewbourne Oil. This is number 44 on our docket. It's 24337. Mr. Bruce?
Mr. Examiner, Jim Bruce representing Mewbourne, and I do have my witnesses online.
And what are you seeking here?
Mr. Examiner, in this case, Mewbourne seeks the approval of a proximity tract Bone Spring well unit covering the west half of section 15 and the west half of section 22, 26 south, 32 east. Exhibit 1, and there are a couple of things I'll get back to at the end, but let me just run through the exhibits really quickly. Exhibit 1 is the pooling checklist. Exhibit 2 is the statement of Mr. Brunson, Mewbourne's landman, who was previously qualified by the division. Contains the usual information, the C-102s, the land flats. There are a number of wells on this well unit. When you get back to Exhibit 2B, you will see that the only party being pooled is Chevron USA Inc. And that's noted on Exhibit 2B. And then, of course, the usual materials, the proposal letter and the AFEs. Exhibit 3 is the geologist affidavit. Justin Roeder is a geologist. He also has previously qualified to be for the division and has been recognized as an expert petroleum geologist. Again, the normal exhibits, a locator plat, structure map, actually 2 structure maps and 2 cross sections, because they're going after first the Bone Spring and the second Bone Spring. And a justification for the stand-up units is given in Mr. Roeder's affidavit. Exhibit 4 is my affidavit of mailing. notice letter timely sent to Chevron. They did return a green card, so there's no publication notice. And then Exhibit 5 is the application and the proposed notice. I would note that in the, Mr. McClure can always find something with my pooling checklist, but so yesterday I went through everything and detailed where I got some stuff wrong, and this is partly due to my printing problems I'm having currently at the office. On the first page of the pooling checklist, on the building blocks, I had the incorrect acreage. It should be 40 acres rather than 30 acres. I mean, 320 acres. And in this case, Mewburn is seeking to pool from the top of the first Bone Spring sand to the base of the Bone Spring. They're omitting the very top, the Avalon Bone Spring. And I would, after I get the exhibits admitted, Mr. McClure may have some questions regarding that. So I would move the admission of exhibits 1, 2 through 2D, the landman's materials 3 through 3F, the geologist materials, exhibit 4 and 4A, the notice materials, and then exhibit 5, the application and proposed notice.
Are there any objections? Not hearing any, your exhibits are admitted into evidence. Mr. Bruce, before we go to Mr. McClure, are you saying that you need to revise something in this packet?
Exhibit 1, the pooling checklist.
That's the only exhibit you need to revise.
Subject to Mr. McClure's.
Of course. Okay. So we have exhibit 1, and the revision will be what now? The one thing for sure, the building blocks on page 1. Yep.
And then if Mr. McClure desires more definition of the depth severance that is in here.
Okay, Mr. McClure?
Thank you, Mr. Hearing Examiner. I do have a fast question for Mr. Bruce. It's not related to the pooling checklist, though. I think you should be fine there with the change that you have already identified, Mr. Bruce.
Thank you.
However, can you please confirm for me when written notice of this case was provided?
Yes, sir. Only certified notice was given, and that was mailed on March 14, 2024, and the green card was signed by Chevron March 19, 2024. I did not do a certified notice spreadsheet because there's just the one interest owner.
Hey, thank you, Mr. Bruce. I have no further questions for this case, Mr. Hearing Examiner.
Mr. Bruce, how long will it take you to submit a amended exhibit packet with a cover letter?
Because of the printing problems I referred to, I know I've committed to doing some other ones, but I'm kind of working around my computer situation. If I could have until Monday on this and any others I may have to do. Close of business Monday.
Fine. Okay, we will take this case under advisement with the caveat that you are filing an amended exhibit packet.
And one question with respect, just because I've sometimes have difficulty uploading packages, exhibit packages to the division website. So all of the remaining cases have parts 1 and 2. There is no change to part 2. It would only be to part 1 if I could just do the part 1.
Definitely.
Thank you.
Mr. McClure, he's going to be correcting the building blocks and the depth severance. Is that your understanding?
Mr. Hearing Examiner, my understanding is just the building blocks.
You did not request
Okay,
anything.
very good. So not depth separates, that's why I'm checking. Okay, you got off easy that time. All right, we're now moving on to 24338 Marathon Oil compulsory pooling application, entries of appearance.
Good morning, Mr. Examiner. Dina Bennett on behalf of Marathon Oil Permian LLC.
Ms. Bennett, are there any other parties?
Yes, there is one other party, and it's Ms. Shaheen, and I see her on the call.
Ms. Shaheen?
Thank you, Ms. Bennett. Sharon Shaheen, Montgomery and Andrews on behalf of SK Warren Resources. And we have no
Ms.
objection to this case.
That was where I was
proceeding by
going.
affidavit.
Will you say that again, please?
I'm sorry, SK Warren has no objection to this case proceeding by affidavit.
And have you reviewed the exhibits?
Yes, I have.
Okay, are there any objections to any of the exhibits?
No objections to any of the exhibit.
Thank you, Ms. Shaheen. Ms. Bennett?
Thank you. In this case, Marathon seeks an order pooling uncommitted interests in a standard 960-acre horizontal spacing unit underlying the west half of sections 22, 27, and 34. And on Monday, actually, we filed the exhibits, and our exhibits include the usual exhibits. The checklist, the affidavit of Farley Duval, who's previously testified before the division, and the affidavit of Greg Borachowski, the geologist for Marathon, who's also previously testified before the division. And then tab D is my self-affirmed declaration with notice, and notice was mailed on March 14th, 2024. One item that Ms. Shaheen and I discussed yesterday or the day before is that on the compulsory pooling checklist, there is a place to identify entries of appearance, and I inadvertently left off SK Warren. And so with the division's permission, I'd like to file an amended exhibit packet today that identifies SK Warren as entering an appearance in the case on the checklist.
Okay.
Other than that, I would ask that the exhibits in tab A, tab B, tab C, and tab D be admitted into the record in case 24338, and that this case be taken under advisement.
Any objections? Hearing none, tabs A, B, C, and D are admitted into evidence. We will expect a amended checklist to be submitted with an amended exhibit packet with a cover letter explaining what the changes to the checklist. Mr. McClure.
Mr. Hearing Examiner, I don't have questions, but I do have an additional change or additional amendment they need to make
In the checklist?
in the checklist and the Form C-102s.
Okay, please proceed.
Thank you, sir. Ms. Bennett, in this particular area, there's actually two different pools.
Okay.
So on the pooling checklist, we'll need to amend that to include both of these pools.
Do you have the information you need?
No, I do not.
I didn't think so. Mr. McClure, what information does she need?
Oh, absolutely, Mr. Examiner. I apologize. I was bringing up the page on my other screen over there. Yes, Ms. Bennett, you currently have pool 64550 on the pooling checklist. That actually, originally I thought it was correct, but now I'm looking at it a second time. It looks like you have the wrong pool code on that. The correct pool code for that pool is 64450.
64450 instead of 64550.
That is correct.
Okay, I think I'm sorry, Mr. McClure, but I think that's due to my own dyslexia. If I'm looking at the C-102s, the first one of which starts on page 15 of 87, it is 64450 for the pool code. So I think I just made a mistake in terms of this particular pool on the checklist, but I'm also understand that there may be a second pool.
Yes, ma'am. The additional pool is well, I'm not even going to try to pronounce the name, but the pool code is 42780.
42780.
Yes, ma'am. And are you going to be able to get the pool name off of our system, or would you like me to spell that for you?
No, I can get it off of the system. If you could though, Mr. McClure, which sections does pool code 42780 cover?
Ms. Bennett, that was exactly what I was getting ready to provide for you.
Okay, thank you.
Because you'll need that for the Form C-102s. The Will Lake is only within section 34. The other pool, 42780 pool, is in both sections 22 and 27.
Thank you.
And if you could, are you aware of how to properly prepare the Form C-102s in instances like this?
I will restate my understanding and you can let me know if that's the division's preference. And my understanding is to create a separate C-102 for each pool. And the C-102 per pool will designate which part of the unit is dedicated to that pool. That's my understanding, is that we would be then submitting 2 C-102s for each of the wells, 1 per pool.
Yes, Ms. Bennett, that is correct. And if you could please provide that to the division, in addition to the changes made to the pooling checklist.
Thank you, Mr. McClure. We will do that. I would ask the division to allow me a little more time then to get amended C-102s. So if I could have through the close of business on Monday, that would be great.
April 8th, close of business. So we'll take this case under advisement once you submit the amended checklists and the C-102s.
Thank you.
Perfect, thank you. I'm now calling Novo Oil and Gas 24339.
Yes, Jackie McLean from Hinkle Shaner on behalf of Novo Oil and Gas.
It looks like we have Ms. Kessler enter.
Yes, sorry. And Ms. Kessler just emailed us and let us know she had to leave, but she has no objections to this case proceeding by affidavit.
And normally I ask, and I'm not able to do so, if she has reviewed the exhibits and has any objections to any of the exhibits. So would you send her a email or?
She said, please feel free to note that we have no objection here.
Okay,
Just observing.
Okay, Ms. McLean, please proceed.
Okay, thank you. And this is another one of those requests for an order extending time to commence drilling. And in case number 24399, Novo is requesting that the division extend the deadline to commence drilling the Tickety-Boo wells until April 13th, 2025. And we submitted Exhibit A, land testimony of Mason Maxwell, who has previously testified before the division, and accompanying exhibits, as well as Exhibit B, notice testimony and accompanying notice exhibits. And I ask that Exhibits A and B be admitted into the record and case 24339 be taken under advisement.
Are there any objections? Well, we know that Ms. Kessler doesn't object. Are there any other objections? Not hearing any, your Exhibits A and B and subparts are admitted into evidence. Mr. McClure?
Mr. Hearing Examiner, I have no questions for this case.
Very good. This is taken under advisement. Thank you.
Thank you.
Okay, let me take some notes and then we'll move on. We are going to Mr. Bruce again for Mewbourne Oil case 24344. Mr. Bruce, I don't know if those are in some way associated with 24345, 46, 47.
Yes, they are, and I would ask that they all be called one at a time.
So I'm calling all cases 24344, 45, 46, and 47. Entries of appearance, please. So would you state it for the record, please? Thank you, sir. Please proceed.
Mr. Hearing Examiner,
Yes.
I think Mr. Bruce's microphone might be off.
Yeah, I
Unless
think it's
we're
on.
hearing him on a.
You're right. It's on now. Thank
Okay,
you.
so Jim Bruce representing Newbern. First of all, the witnesses in the cases, they're all the same. Mitch Robb, the landman, who's previously been qualified, and the geologist is Tyler Hill, who was previously qualified. In the first case, Newbern seeks to pool the Bone Spring Formation in the west half of section 26 and section 35, 23 south, 28 east, for purposes of drilling 2 Bone Spring wells. Exhibit 2 is the landman's affidavit. Again, it contains usual information regarding the C-102's Exhibit 2B contains information on the interest ownership, and it does indicate by asterisk besides certain parties' names that they are being pooled. So that is identified on the 3rd page of Exhibit 2B. Then it contains, of course, the summary of communications, the proposal letters, and the AFEs, or the AFE, I should say. Exhibit 3 is the geologist affidavit with the usual locator map, the structure map. There are 2 cross sections and the horizontal drilling plans.
Mr. Bruce, has your geologist been qualified in?
Oh,
as an
yes,
exhibit?
yes.
Thank you, sir.
Many times.
Great.
And, shows that the horizontal drilling will properly develop this property. Exhibit 4 is the affidavit of mailing. The affidavit of mailing for each case is different because different groups of persons were named in each case. And then there is one consolidated affidavit of publication marked Exhibit 6, and that was timely published on the 19th of March, so that is proper. And obviously on the affidavit of mailing, you can see it specifically identifies for each case the parties whom Newbern seeks to pool. And then Exhibit 7 is the affidavit, application and proposed notice. There is in Part 2, because of these printing problems I mentioned, I prepared, but I could not print up in time the certified notice spreadsheet, so I need to supplement Part 2 of the exhibits simply with the certified notice spreadsheet.
Mr. Bruce, are you saying that in each of the 4 cases you need to supplement?
Each of the 3 cases, yeah.
3 cases? I thought it was 4 cases.
No, the final case, which is 24347, is separate from these, so it's.
Okay, fine. So so are you adding an exhibit or are you correct?
I am adding an exhibit 5, which is noted on the cover sheet, the certified notice spreadsheet, but I couldn't print it up, so I couldn't combine it when I was scanning things.
So the 3 packets for the 3 cases are all missing Exhibit 5.
That is correct.
Even though they're in the index.
Correct.
Fine. So how long do you need to file amended exhibit?
If I could do them all on Monday.
Monday, April 8th. We have a lot going on April 8th. Okay. Close of business, right? Okay, very good. So let's get these admitted into evidence. Are there any objections in case 24344 to exhibits under parts 1 and 2, 1, 2, 3, 4, 5, 6, 7? Not hearing any. They're all admitted, even though there isn't an exhibit 5. At this point, there will be. Mr. McClure, are there any questions on this single case?
Yes, I do, Mr. Hearing Examiner.
Go right ahead.
Mr. Bruce, if I can bring your attention to Exhibit Part 1, page 14 of 18. This is the letter that was provided with the AFEs to the interest owners, I believe. Is that correct?
You are correct.
on the copy that was provided to the division, there's some hand-drawn corrections made to this letter. Is that correct?
Yes, sir. And that was done by me because when you go through the division's records and you go through this proposal letter, and then when you go through the AFE, the C-102s, this well might have originally been the 403H well, and the landman could confirm this. But when you go to Exhibit 2A, or actually, this is the next case. If you go to, but regardless, if you go to Exhibit 2A, in the next case, the C-102 is indeed identifies the well as the 404H well.
Yeah, Mr. Bruce, I guess I at this exact moment, I didn't go look at that just now. However, I am aware, well, from when I reviewed the packets, that it does appear that one of the numbers had changed.
And what I did was I went through what was in the divisions file, the C-102s here, and the letter, and the footages all match up for that 404H well. So it might have been a typo in the letter, might have been a change to the well number.
Mr. Bruce, I guess well, let me ask this question. Is it the intent of Mewbourne to provide in this application the letter that was actually provided to the interest owners, or an easier for the division to interpret letter to the interest owners?
Well, I mean, this is the letter, you pointed out the letter that was sent. And I noticed this typo, and I didn't know whether to change it or let you raise the issue and say that well numbers don't match up.
And Mr. Bruce, I definitely understand your dilemma here, of course. My only concern is that in our case file, we don't see the actual letter that was provided to the interest owners. So I guess
I mean, I do have on my computer a copy of this letter unmarked. I could submit it.
Thank you, Ms. Bruce. I'm almost wondering if that may be the most appropriate solution here, was if you wanted to provide us the initial letter.
Yeah, this is the
in addition to this, if you'd like. Oh, excuse me.
Yeah,
I'm sorry, Ms. Bruce.
That would be fine.
Okay, thank you, Mr. Bruce. Another question, Mr. Bruce. When was written notice of this case provided?
It was mailed. On March 14th.
Thank you, Mr. Bruce. One other quick note to point out, and this affects this case and the following two cases. Just so you're already aware of the issue for those cases when they do come up. On your pooling checklist, it appears that you had accidentally wrote the wrong pool code down. Are you prepared for me to provide you with the correct pool code there?
Have at it.
Okay. In the correct pool code would be 15011.
Okay. I will correct that too. More August 8th material for you, Mr. Examiner.
In addition to that, Mr. Bruce, it appears the same. Oh, um, in addition to that, it appears this same accidental, very simple typo was continued on to
I
the
was
form.
planning on taking care of that for all three cases.
Yes, sir. But I mean, this pool code was also used on the form C-102.
Correct.
So we'll need to provide amended C-102 as well.
Yeah.
Okay, thank
Understood.
you. I'm sorry, was it Mr. Bruce?
I said understood.
Thank you, Mr. Bruce. I have no further questions for this case, Mr. Hearing Examiner.
Mr. McClure, would you give me a list of what Mr. Bruce needs to file so that this case can be taken under advisement?
Of the things that I just pointed out, Mr. Hearing Examiner, Mr. Bruce will need to submit an amended pooling checklist, amended Form C-102s, and a supplemental exhibit with the uncorrected letter provided to the with the AFEs.
And then we also need Exhibit 5.
Yeah.
Correct.
Very good. I have a list of what needs to be amended. When will that be submitted?
Monday.
Monday, close of business. Okay, so Mr. McClure, we'll take this case under advisement with those supplemental exhibits filed timely. Let's move on to the next case, which is 24345. Mr. Bruce, is it going to be the same here?
Yes, sir. The same witnesses gave their affidavits, the testimony. As you can see, these wells are all adjoining each other. In this one, it's the east half, west half of sections 26 and 35. And all the geologic data presented is the same. The land data is the same, except obviously you're on an adjoining tract of land. Affidavit of mailing notice was mailed, again, a separate notice list, but the letter went out March 14th. I do need to provide the certified notice spreadsheet. And there is a timely published affidavit of publication and the application and proposed advertisement. But the same 4 items that Mr. McClure requested in case 24344 are applicable to this case too.
All right, let's deal with the exhibits first, then we'll go to Mr. McClure if he wants to point out any other deficiencies. Let's see, 2, 4, 3, 4, 5. I have to pull up the packet. 2, 4, 3, 4, 5. 2, 4, 3, 4, 5. Okay, I see here 2 exhibits, a part 1 and a part 2. I have exhibits 1, 2, 3, 4, 5, which is missing, 6 and 7. Are there any objections to those admitted into evidence? Mr. Bruce, they are admitted into evidence. Mr. McClure, knowing that Mr. Bruce is going to fix certain items, are there any other questions in this case?
Mr. Hearing Examiner, I have no other questions in this case.
Okay, let's move on then to 24346, since we're taking 24345 under advisement with the additional evidence. Let's go.
And in 24346, virtually the same exhibit package. This particular application covers the east half, west half of section 26 for a Bone Spring well. Again, the pool code is wrong in the checklist, so that'll be cured. There will be, again, for the landman's affidavit, there will be the unedited proposal letter. The geologist's affidavit is the same actually for all three cases. The affidavit of mailing, it again was mailed out March 14th. The address list is separate from the other two cases. The certified notice spreadsheet needs to be added in, and the C-102 needs to be corrected. The affidavit of publication was timely, and the Exhibit 7 is the application and proposed notice. And so I would move the admission of Exhibits 1 through 7 plus subparts.
Any objections? Not hearing any, they're admitted into evidence. Mr. McClure, are there any specific questions that you've not already addressed in previous cases?
Mr. Hearing Examiner, if I may, a quick question for you.
Yes, for me?
Yes, if I
Okay.
may, sir.
Yes, go ahead.
The last case that we just took under advisement, that was docket number 49 or docket number 50?
Neither. Hold on a second. That was 24345. Oh, docket number. I don't know. Let me look.
I apologize. So the case 24345 is fine. I had thought that I was just wanting to confirm we have not taken 24347.
No,
under
not yet.
advisement.
That's the last of Mr. Bruce's cases to come before us.
Okay, thank you, sir. I apologize for my confusion there. For some reason, I was concerned we'd skipped over a case, and while I was writing my notes down. The question and before me is whether I have any questions for case 24346. Is that
Yes.
correct? With consideration to already prior acknowledgement of the pool code being slightly wrong, I have no further questions for this case.
Okay. Mr. Bruce, we're on your last case, 24347.
Yes, Mr. Examiner. The witnesses for this case, the landman is Thomas Sloan, who has previously testified before the division, and the geologist is Charles Crosby, who has testified multiple times before the division. They were both qualified as experts. Exhibit 1 is the pooling checklist, and there is on the first page, there is one error that I noticed. Right in the middle, it says pooling this vertical extent. This is a Bone Spring well. These are Bone Spring wells, and I wrote down Wolfgamp, and so I need to correct that. In these cases, Mewburn seeks to pool the east half of section 9 and east half of section 4, 19 South 34 East, which is a non-standard unit, which is also requested to be approved by this application. There are two wells that are identified, 2/3 Bone Spring wells being pooled. The landman's affidavit contains the usual C-102s, land plats, showing the parties. Exhibit 2B shows the parties being pooled. There are both working interest owners and record title owners being pooled. Obviously, the record title owners for purposes of communitization agreement. The parties being pooled are indicated in red ink on the land information, exhibits 2B and 2C. Obviously, there is a proposal letter, summary of communications. And then for purposes of the NSP, exhibit 2G outlines the well unit, and then it shows the offsetting tracks and identifies on the second page of that exhibit the persons who needed to be notified of the NSP. The geologist affidavit submitted as exhibit 3 contains the usual structure map, cross-section, horizontal drilling plans, and shows that each quarter section in these well units will contribute more or less equally to production. The affidavit of mailing, in this case, there are 2 letters. Exhibit 4 is my affidavit. Exhibit 4A is the letter that went out to the working interest owners and record title owners. Exhibit 4B is a letter that went out to the offset interest owners regarding the non-standard unit. Exhibit 5 is the certified notice spreadsheet, and I did get one in this group, so that is present. And there is a timely published notice affidavit of publication. And then Exhibit 7 is the application and proposed ad. I would move the admission of Exhibits 1 through 7 with subparts, and I will have to make a minor correction on the pooling checklist.
Okay, I have your exhibits, part 1, numbers 1 and 2. I have your exhibits. Wait a minute. Let me start over. So I'm looking at the wrong page. Yes, I have your exhibits 1 and 2, and then I have your exhibits in a second packet, 3 through 7. Are there any objections to these exhibits? Not hearing any of these exhibits are entered into evidence. Mr. McClure, are there any questions in this case?
Yes, I do, Mr. Hearing Examiner.
Go ahead.
Mr. Bruce, can you please confirm for me when written notice of this case was provided?
Yes, sir. It was. I think if you go to Exhibit 5, it'll show that all of the letters, both to the interest owners and the offset working interest owners, were sent on March 14th. And then the affidavit of publication shows that it was published March 20th, so it was timely.
Thank you, Mr. Bruce. Actually, now I'm looking at my notes again. I actually didn't have the note for this case because it does state exactly as you just laid out in Exhibit 5. However, I do have an additional change to your pooling checklist as well as Form C-102s. In addition to your currently identified pool, which is the pool code 50460.
Yes.
There is another pool that also needs to be included here.
Okay.
The pool code for that, when you're ready, sir,
Yes, sir.
is pool number 21650.
21650. And what's the name?
The name is E-K semicolon Bone Spring.
Yeah.
And the EK Bone Spring is within Section 4. Where in the Quail Ridge Bone Spring is in Section 9. So we'll need to submit the amended pooling checklist with your prior approved or prior referenced pulling this vertical extent change, as well as Form C-102s.
Yeah, and it might take a few days to get the C-102s changed. The other stuff is easy enough. So,
Thank you, Mr. Bruce. Mr. Hearing Examiner, I have no other questions.
Thank you. So when are you going to submit that?
let me contact my clients in a few minutes and ask when the new C-102s can be submitted.
Okay. We'll still be here. And if we're not, send us an email and let us know. But do you feel as though Tuesday, April 9 is enough time?
I will find out and email you folks.
Very good. I'm going to put a deadline of Tuesday, April 9. If you can't comply with Tuesday, April 9 at close of business, send me an email and let me know how much more time you need.
Thank you.
Okay, thank you. Let's recall 2 cases for Ms. Vance. Ms. Bennett, do you have other business before the division? You do? Is it a case that we need to recall? Oh, in these cases that we're recalling now?
No, earlier today on the phone, when I was driving in, you asked me to check the case files or my notes on certain Franklin Mountain Energy cases, so I'm,
You have the information?
yes, and I'm happy to do that after.
Okay, well, if it's just giving me a list of case numbers, let's get that over with so you can leave. But which case was it in reference to? Which case did I call?
This was in reference to the first 5 cases or so that were on the docket, and.
Hold on, let me get to it.
Mhm.
Okay. Go back up. So I had called 23659 through 23661, 23811, and 23813. Is that what you mean?
Yes.
Okay, now you're saying that those are going to be consolidated with some cases that are not. No, you're not saying that.
No.
No, what are you saying?
Okay, so during the status conference for the cases that you just read off, we talked about whether the hearing examiner would consider moving these cases to be on the same date as other Franklin Mountain Energy and MRC cases, but the division or the hearing examiner decided against doing that. And instead asked us to revert back with some dates for a contested hearing.
But I also couldn't find the dates or the dockets for the other cases that you mentioned.
That's correct.
Okay.
And so I was coordinating with Ms. Pena in my office, and she looked at the transcript for the March 7th hearing. And the transcript shows that for the cases I read to you earlier today, we all agreed for a status conference on May 16th. And we needed to file continuances for those. And by we, I mean both Franklin Mountain Energy and MRC. And in looking at the case files, it appears that neither one of us has done that yet. And so on our to-do list will be to file the continuances to clarify that
And
for
could
the
I
division.
have, very good. And these are all consolidated together, the ones you're about to give me, right?
Those are consolidated, yes.
The ones that we're talking about that are not on the docket for May 16, but need to be.
Exactly.
Great. Can I have a list?
The case numbers are 23853 through 23856,
5, 6, yes.
23857 through 23867,
6, 7, yes.
24256 through 24258.
5, 8, yes.
And then the competing cases are case numbers 24233,
I'm sorry, 242.
33,
33.
mhm,
33, yes.
through 24244,
4,
and 24245
4, 5,
through 24249.
4, 9. So why is it that you don't just say 24233 through 449?
Because I think they're probably east half, west half cases or slightly different spacing units.
Fine. Okay. So these cases, you and, is it Mr. Felderwer?
Yes.
Okay. Are going to file continuances for all of these cases to move them to the May 16 docket for the purposes of a status conference. Is that right?
That's right.
Because I don't have the verbatim transcript from March. What were we trying to achieve in March that we said we were going to move these to May 16?
The parties, these cases were set for a contested hearing on March 7th. And the parties are in discussions, and so ask that these cases be continued for a status conference to discuss the outcome of those negotiations.
Yeah, okay, I understand. So we're going to have a final status conference then on May 16th. Okay. That's important to know for me and for you. Okay. Okay, now, what about the first 5 cases that we talked about today? Are they related to these cases?
They're related in that they involve the same parties
That's all.
and the same general set of negotiations,
Okay,
but they're different acreage.
fine. So then the outcome of today's docket call on cases 1 through 5 was that by April 8, close of business, the parties will propose hearing dates for a contested hearing for those 5 cases, but not for these cases.
That's correct.
That's what I'm trying to distinguish between. Okay, I understand. I'm glad you clarified that for me. Is there anything else you think I need to know?
No, that's all.
Very good. So thank you. You may be excused. And Ms. Vance, let's go back to your 2 cases. Let's deal with the first one first and the second one second.
I think that we got everything taken care of with the EOG case. I came back.
Can I have a case number?
It was, sorry, 22947.
Hold on. 22947. Let me get back to it. I know we're in recess on it, but let me open back up the, okay, so what was the issue? Why did we go on recess in that case?
That related to making sure that we had all of the notice, and I am going to file a revised hearing packet this afternoon that has all of the notice to show that the parties that we're pooling have been properly noticed by both mail and by notice of publication.
So we have some additional exhibits that you emailed both Dean and I.
That's correct.
Okay, very good. So what you're saying now is that all of these exhibits will be added to an amended exhibit packet and refiled.
That's correct.
Okay, so hold on one second. And I asked, so we have 2 emails. Why do we have 2 emails?
So it's 2 separate notices. This case was originally filed back in 2022, so I provided the notice from 2022. We also did new notice in December 2023, and then we did a recent notice last month because just to cover all bases, and one of the addresses changed, so we wanted to make sure that we covered that.
So in your cover letter, please explain what you just explained. That'll be very helpful. Mr. McClure, have you had time to look at these exhibits?
Mr. Hearing Examiner, I have had time to look at them.
Do you have any questions for Ms. Vance or any of her witnesses based on these exhibits?
Yes, Mr. Hearing Examiner, I do have questions for Ms. Vance.
Okay, Ms. Vance, do you remember, did I swear in any of your witnesses on this case before?
I don't believe so, but they have already dropped off because I thought that we were done with this case. So hopefully these are just questions that I can answer. If I do need to email them and have them sign back in, I will.
Okay, I'm not sure why you felt we were done with this case since we were in recess and we had issues with the exhibits, but I guess you take that under your own responsibility. Okay, Mr. McClure, do you have any questions for Ms. Vance and not her witnesses?
Yes, I do, Mr. Hearing Examiner.
Please.
Ms. Vance, if I may direct your attention to your original exhibit packet, page 71 of 72.
You'll have to give me a minute because I thought we were done with this, so I closed out of everything.
Yes, ma'am.
And you said that was page 71?
That is correct.
Okay.
Is this the list of interest owners that the notice from March 20th, I believe, was provided?
Yes.
That being both Marathon and Kinian?
Yes.
Okay, if I may draw, okay, and is it your
So I would
belief
just,
that
I
Tinian
can-
was noticed prior to this?
Okay, hold on a second. We're recording this and parties can't speak over each other. So Ms. Vance, hold your question for a moment or your feedback. And Mr. McClure, would you start over again?
Yes, yes, Mr. Examiner, I will. Ms. Vance, is it your belief that Tinian was noticed by a direct written notice prior to the March 20th date?
give me one moment. I'm gonna pull up some feedback that I got from EOG. I would note that Tenian is not being pulled. So they were provided notice, but if you go to the exhibit, and that would be Exhibit C4, and page 28 of 72, you will see that they've executed the JOA and elected to participate, so we're not pooling them.
Okay, Ms. Vance, so then Tinian does not need to be noticed of this case, is that correct?
That's correct.
Okay, thank you, Ms. Vance. Mr. Hearing Examiner, I have no further questions.
All right, so let me make sure I understand. We have 22947, which we will take under advisement, is my understanding, with the amended exhibit packet to include 6 new exhibits, which have not been taken into evidence.
Well, yes, that's correct.
Right, which we'll deal with before we end this hearing. Okay. And you'll provide a cover letter explaining what's going on. Is that the only amendment to the exhibit packet in your understanding, is that you're adding these 6 exhibits?
That's correct.
All right, well, since you haven't marked them, let's identify them in some way so that it can be shown that we've done the proper thing here. So let me get back to my email. So why don't you identify them? Why don't you identify each of the 6 exhibits now and ask for me to admit them?
So the first email that I sent, which is the notice from 2022, includes a sample notice letter that was mailed out on July 15th, 2022, along with the tracking information and the notice of publication that was also submitted to the paper in July of 2022.
All right, let's deal with those now. So if these are notice things that are these within your personal knowledge?
Yes.
Good. So you dealt with these yourself?
Well, yes.
Okay. Would these typically be included in a affidavit?
Yes.
So why don't you amend the packet to include an affidavit from you that admits these under your, signed affidavit?
I can do that.
And I will admit these 3 exhibits now into evidence unless there is an objection from someone, and I'm not hearing one. So I'm going to make a note that your affidavit will also be, either you're going to have a second do you already have an affidavit in the packet?
I do, and I was going to recommend that I just file a revised self-affirmed statement. And usually what I do is I reference the mailing reports, but make reference to the notice letters that went out in my self-affirmed statement.
Okay, for the 3 that we 3 exhibits that we dealt with in 2022, which are admitted into evidence, your affidavit can affirm those. And then what about the other email you sent?
So the next one was for December 2023. And again, what I included was a sample copy of the notice letter that went out along with the mailing report. to the parties that received that notice letter and as well as the notice of publication, affidavit of notice of publication. And again, I would just recommend I will revise my self-affirmed statement so it's all consolidated into one statement to cover all of the notice that we have sent in this case.
Okay, and in your exhibit packet, I then presume you will have an amended affidavit followed by multiple exhibits that we are about to enter into evidence and have entered into evidence. Please copy me with the email that you give me a courtesy copy of your exhibit packet when you are filing it so I can look at it. So unless there is an objection, we will admit these three December 23 exhibits. Is there anything further on this case?
Not from myself, no.
Mr. McClure, is there anything further from you?
And no, sir.
Okay, then this case will be taken under advisement once we receive that amended exhibit packet. So let's recall your other case.
Are you looking for the case number, Mr. Hearn?
I am. In my notes, I'm looking, but I
It
don't
is-
see it right off the bat. What case number is it?
24335.
24335. Okay, please proceed.
Thank you, Mr. Hearing Examiner. Well, my feedback, I did confer with my client and I also followed up with one of my colleagues. And what I would suggest is that we move forward with this case because it relates to the acknowledgement of the unit. Anything related to requirements, administrative filings can be taken up separately. And because there may be a issue of, interpretation of the rules, I would recommend that we take this up, if needed, with Division Counsel to get clarification.
Okay, Mr. McClure, in your own words, why did we recess this case?
There currently is a disagreement between the BLM's approval letter and that Exhibit D in the unit case. Both of those are not true, cannot be true at the same time unless this additional paperwork is filed by Oxy.
Okay, so there's a contradiction in the evidence.
That is correct, because the division cannot issue a spacing HSU, which represents the drainage of the wells, without the additional application submitted.
Let me get to the exhibit. Would you give me page numbers of the conflicting evidence?
Yes, sir.
And Ms. Vance, you have that case pulled up in front of you?
I do, and I would like to know exactly where Mr. McClure is
And so would I, that's why I'm
pointing.
asking. Go ahead, Mr. McClure.
Yes, sir. I apologize. I'm still.
Sure.
Okay, I do have the page numbers. Let me
Okay.
get the exhibit actually brought up on my side, but I'll give you the first page number. The paragraph 3 of BLM's approval letter is on page 283 of 293.
Okay, so paragraph 3. So here's what I see. It starts with the words participating areas?
That is correct, Mr.
All
Hearing
right.
Examiner.
Now, this paragraph is in conflict with what else?
On page 278.
278. So we have, hold on a second. 283, paragraph 3. 278, is there a paragraph number on 278?
On paragraph number 2, there's a reference to a participating area.
Okay, let me read paragraph 3 first, then I'll go to paragraph 2. And what part of paragraph 3 is conflicting with what part of paragraph 2? In your opinion?
In my opinion,
Yes.
paragraph 3 says that this unit shall be a divided unit.
Yes, I see that.
What that means is that each well, once economic determination has been made, will have its own individual drainage brought in as its own participating area.
I see. And then take me to paragraph 2 in Exhibit D on page 278.
Oh, go ahead.
Go ahead. Go ahead.
It states that the initial participating area shall cover all of sections 24, 25, 35, and the south half of 26.
Okay.
And what page was that again?
278.
In paragraph
2. The second part of paragraph 2. Now, Mr. McClure, what is in conflict in paragraph 2 with paragraph 3?
Well, in order to bring it in as a single package, it would mean that they'd have to have that as the drainage for the wells.
And you're saying that because paragraph 3 says that it's a divided, then they need to have 2 packets, you're saying?
Unless they also submit an NSP in order to get those aligned. I mean, essentially what it is, each well is going to have its own subset of drainage.
Right.
So you'd have more than one well that would have to make its economic determination made.
Okay, let's see what Ms. Vance has to say about this.
Yeah, I'm still confused. So if Mr. McClure can explain that again, what the rationale for the NSP, that would be great.
So Mr.
ahead.
McClure, pretend you're talking to lay people who don't know anything about oil and gas.
The way that the division represents the drainage for each well is its dedicated acreage that we put on the form C-102. This is also referred to as like the horizontal spacing unit assigned to that well. Without asking for a non-standard HSU, the division would not be able to assign a spacing unit that takes up the entirety of this unit within a single HSU.
Does that make sense, Ms. Vance?
I understand, but if we go to the application and we look at what this unit is, what we're applying for, you can see in paragraph 3 on page, paragraph 3 of page 3, you can see the unitized interval that is part of this unit. Again, I disagree with Mr. McClure regarding the requirement for the NSP for this. And I would just say, that is a separate issue that can be dealt with outside of this hearing, because that's an administrative process. And this is purely acknowledgement of the unit itself that has been approved by the BLM and that there is a fully executed unit agreement for. So I think that what he is getting at is a legal issue that we can take up with the division council to get clarification on.
So Mr. McClure, I understand your issue, and I've heard Ms. Vance. How do you want to proceed?
Well, I guess, to be honest with you, I was not anticipating the conversation be drawn out quite to this extent, because I just have a quick follow-up question, provided that Oxy would intend to establish an HSU, which takes up the entirety of the unit.
So Mr. McClure, what I hear you saying is that you would be able to take this application under advisement if what you just said is true.
Yes. I agree. I would agree with that. Well, I'd ask one quick follow-up question, but I'm pretty sure what the answer is going to be. I just put them on. I just have it in the record for the answer.
Okay, well, go ahead and ask the question.
Okay. Well, my question would be is assuming that Oxy gets an HSU assigned for the wells here, which takes up the entirety of the unit, then in Ms. Carr's opinion, would these two parts of the application be now in agreement?
You're presuming that Ms. Carr feels as though the two parts of the application are not in agreement now.
That was not her indication, but when she had stated before, or excuse me, let me repeat that. In her prior testimony, she had seemed to indicate that she believes they're in agreement now already, without the addition of what I just laid out.
The HSU.
Correct.
But you're asking the witness. I don't think that's a proper question. I think there's another way of getting to it, but I don't think that's the proper question because she's already testified she thinks that they are in agreement. So you're asking her to assume that they're not in agreement.
I mean, you raise a good point.
I'm not trying to do your job for you, Ms. Vance, but I just want to make sure that, you know, this record is getting a bit muddy. I think
It is.
I think Mr. McClure, in my opinion, is there any other evidence that you need before you can take this case under advisement?
Well, in order to properly draft a recommendation for the director,
right,
it would be appropriate for me to have a response to my first question at the very least.
Okay, very good. So Ms. Carr is still here. Ms. Carr, you're under oath. Please turn on your camera. And Mr. McClure, would you ask Ms. Carr whatever questions you have for her still? Now, Ms. Carr, you're turning out to be in a different place, but I don't know why. Okay. You're not showing up as Ms. Carr anymore. You're showing up as someone else. But anyway, Ms. Carr, you are under oath. So, Mr. McClure?
Ms. Carr, is it Oxy's intent to seek an HSU which would take up the entirety of this unit?
Yes,
I couldn't hear you.
yes, that is Oxy's intent.
I think you're saying yes, although maybe it's because you're not on the same screen that you used to be with your name in it. Maybe that's why I can't hear you.
All right, yes.
That's
Can you hear me now?
very clearly. Thank you.
Okay, I'm leaning in further to my computer.
Well, it's helping a lot. So, Mr. McClure, your question was answered as a yes. Do you have another question?
No, Mr. Hearing Examiner, that should be fine.
Okay. Ms. Vance, do you have any questions do you want to redirect your witness at all, or do you feel it's fine where it is?
It's fine where it is.
Very good. Okay, Mr. McClure, can we take this case under advisement with that question answered?
I believe so, Mr. Hearing Examiner.
I'd like to get, I believe so. Does that mean, is that a yes?
Oh, yes.
Okay. Good.
Yes, Mr. Hearing Examiner.
I just want to be clear. Okay, very good. We're going to take this case under advisement, Ms. Vance.
Perfect.
So if there's nothing further, this concludes the hearings of the Oil Conservation Division on April the 4th at 12:30 in the afternoon. Thank you, everyone, for your participation. Thank you, Mr. McClure. Enjoy your lunch.
Yeah, thank you, Mr. Hearing Examiner.
Thank you.